In my considered review, the conviction and sentence recorded against the petitioner by both the courts below are contrary to law and devoid of merit. According to the legal petition succeeds and the impugn judgment and order dated 14/12/2010, passed by the learned decision sessions Judge Kalahandi Noapada at Bhavanipatna in criminal appeal number 13 of 2008, and the judgment dated 10th March 2008, passed by learned JMFC Bhavanipatna in 2A CC case number so-and-so as per aside. And criminal revision petition is allowed. It's highly stated.
Item 2.
The evidence adduced by the prosecutions are unimpeachable against the petitioner, taking into consideration the evidence on record and the testimonies of PW 5, 6, 8, and 10. No fault could be found in the conviction recorded by the courts below. However, the sentence awarded by the courts below is required to be altered in view of the fact that the injuries caused by the petitioner to the victim are simple in nature, and 25 years have already been lapsed between. Accordingly, this court reduces the sentence awarded by the court below from the RI of 7 years to RI of 1 year, and the fine of rupees 1,000 is increased to 25,000 each. In default, the petitioners are liable to undergo simple imprisonment of 3 months. The fine amount to be deposited by the petitioner shall be disbursed to the injured as per the provisions under section 357 CRPC. With this modification, the modification on sentence, the criminal revision is partly allowed.
Item 3.
The petitioner had already undergone about 2 months of substantive sentence. The court below has awarded the sentence of 6 months RI and fine of 2,000 in default of payment of a fine to undergo SI of 2 months. Since the petitioner has already undergone more than 2 months, I am inclined to modify the sentence to that of the sentence already undergone. However, the fine of rupees 2,000 is increased to 10,000 rupees in default of a payment of the fine to undergo SI of 1 month, and the fine of rupees 10,000 to be deposited by the petitioner shall be disbursed to PW2, the injured, as per the provisions under section 357 CRPC as compensation. Partly allowed.
Item 4.
The analysis of the entire evidence goes to show that there was a family dispute. Panchanan had married the informant after the impregnating her. The marriage had taken place only after the intervention of the villagers. There was a panchayat meeting, and under the pressure of the panchayat, Panchanan had married to the informant. When there was a inconsistent misunderstanding between Panchanan and the informant, Panchanan appeared to have left the informant and went to Surat for earning livelihood. The informant, suspecting that the Panchanan had already married to someone, thereafter he had initiated the criminal proceeding against the accused person. Surprisingly, neither Panchanan had been absconding, and mother-in-law died, and sister-in-law of the informant is not prosecuted. Therefore, the entire sequence of event and the evidence brought on record to prove the sequence of event creates a serious doubt, except a general and bald allegation that the present petitioners have tortured the informant. Nothing specific has come on record to sustain the charges under 498A IPC. Therefore, the petitioners are entitled to acquittal from the charges of 498 capital A and 34 IPC, apart from the acquittal recorded by the court below for offences under section 406 and 34 IPC and section 4 of DPA. Accordingly, the criminal revision is allowed. The petitioners are acquitted from the charges under section 498 and 34 IPC. This was done because somebody was working.
Item 5.
Government that is why it is done. Yes. In view of the aforementioned, the criminal revision petition, although is dismissed and the conviction of the petitioner is upheld, but instead of sentencing the petitioner to suffer the incarceration, I direct the petitioner to be released under Section 4 of Probation of Offenders Act for a period of 1 year on execution of a bond of rupees 5,000 with one surety of like amount to appear and revive the sentence when called upon during such period. During the probation period, the petitioner shall keep peace and maintain good behavior. The petitioner shall remain under the supervision of the concerned probation officer during the aforesaid period. The criminal revision is accordingly disposed.
Item 6.
I have upheld the conviction. However, the quantum of sentence, I am inclined to interfere with the impugn order because of the fact that the incident alleged to have happened in 1996, and the trial court has convicted the petitioner way back in 1997, and the appellate court upheld the conviction and sentence of by a judgment dated 8/11/2007. During the trial and after the conviction, the petitioner has already undergone about 11 months of substantive sentence. Therefore, I am inclined to modify the sentence to that of the one undergone by the petitioner. Accordingly, the judgment of the court below convicting the petitioner for conviction under section 363 IPC is upheld and sentence is modified to that of the period already undergone.
Item 7.
In view of the aforementioned, the criminal revision petition, although dismissed and conviction of the petitioner is upheld, but instead of sentencing the petitioner to suffer any punishment, I direct the petitioner to be released under Section 4 of Provision of Offenders Act 1958 for a period of 1 year by executing a bond of 5,000, and he will be remain under supervision of the concerned probation officer during that period.
Item 8.
I am inclined to modify the sentence awarded by the petitioner while maintaining the conviction. The sentence is accordingly modified from RI of 7 years awarded by the court below to that of the sentence already undergone by the petitioner. The petitioner is also liable to pay a fine of rupees 20,000 rupees in default of payment of the same. The petitioner shall undergo a sentence of SI of 2 months. The fine amount to be deposited by the petitioner shall be disbursed to the informant oblique injured in accordance with the section 357 CRPC as compensation.
Item 9.
20,000 rupees.
No.
Accordingly, the present criminal revision petition, insofar as the conviction is concerned, is turned down. But instead of sentencing the petitioner for imprisonment, Section 4 of Probation of Offenders Act benefit is given with the same direction.
Item 10.
Conviction is maintained, and again the benefit of probation of offenders act is extended.
Item 11.
Yes. In view of the fact that the incident pertains to the year 2005, and the petitioner has already undergone about 10 months in custody, I am inclined to modify the sentence awarded by the court below to that of the sentence already undergone by the petitioner. Accordingly, the sentence is modified and the conviction is maintained.
Item 12.
I set aside the judgment dated 14/10/2009 passed by the learned STGM Cuttack in GR case number so, and the judgment and order dated 3/11/2011 passed by the learned ad hoc additional sessions at FTC Cuttack in Criminal Appeal number 54 of 2009, insofar as the recording of a conviction against the petitioner for the offence under section 353 IPC is concerned, and thereby the petitioner is acquitted for the offence according to the revision petition is allowed.
Item 13.
All the three petitions are allowed, and the charge sheet number 42, dated 29/9/2014, filed by the respondent under section 13(2) and read with section 13(1) C and D of PC Act, read with all the IPC provisions pending before the court of Learned Special Judge Vigilance, Cuttack, which is emanating from the Vigilance case number 25 of 2010 under section so and so, and consequential proceedings arising therefrom, qua the petitioners in all the three cases are quashed.
Item 14.
I have considered the material placed before the court and weighed all the judgments cited at the bar vis-a-vis the fact of the present case. I am of the considered view that the court below has rightly taken the cognizance of offence under section 13(2) and 13(1)(e) of PC Act, read with section 109 of IPC against the petitioner, as there is a prima facie material came on record against the petitioner, since the petitioner has put forth the specific defense explaining the acquisition of a movable and immovable asset factored into the disproportionate asset acquired by her husband. The probative value of her defense cannot be gone into by this court at this stage by virtually conducting a mini trial. The same can only be tested during the trial. This court, while exercising jurisdiction under section 482 CRPC, should not scuttle the trial at this stage. Hence, the petition deserves no merit, and accordingly it is dismissed.
Item 15.
And in view of the findings recorded by me, I am not inclined to quash the alleged offence under section 6 of OPD Act, as has been invoked by the investigating agency by filing the charge sheet. Accordingly, the criminal MC is dismissed.
Item 16.
Discussed all the case law and all, and I came to the conclusion that the only inference that could be drawn from the fact borne out from the record is that the deceased has fell victim of the reluctance of the petitioner to get married and the desperation of the parents of the both sides to get married the deceased to the petitioner. Accordingly, in the light of the discussion, the petition is allowed, and the order dated 28/11/2022, taking cognizance of the offence under 306 IPC against the petitioner in GR case so and so, and all the consequence proceedings are quashed, and accordingly it is allowed.
Item 17.
Having regard to the aforementioned fact and submission at the bar, I am not inclined to entertain this petition at this stage. Rather, I think it appropriate to relegate the petitioner to the learned trial court to urge all the points and seek discharge by moving appropriate application. This is being done only because of the reason that there are overlapping facts germinating from the record, and many documents which are part of the charge sheet have not been placed before this court. Contention of the petitioner that the subsequent incident in the evening by which the petitioner has been roped in, roped in this case is a distinct offence and could also be tasted by the learned court below on the strength of the documents form part of the charge sheet, and on the basis of the face value of the allegation. Certain offences are not made out, could only be seen by the court below at the time of framing of charges. Therefore, it would be appropriate that the petitioner should approach the court below by moving appropriate application in that regard. If such application is moved, the same shall be considered on its merit. Accordingly, the CRLMC is disposed of with the petition.
Item 18.
In view of the discussion in the preceding paragraph, the criminal MC is allowed and the order dated 2/5/2015 passed by the learned JMFC Saintala in GR case number 192 of 2012 corresponding to Saintala case is surrender.
Okay.
Item 19.
In view of the discussion, I am of the considered opinion that no ground are made out to entertain the present petition. However, the petitioner accused persons can raise all the contention discussed above before the learned court below at appropriate time and stage, and the learned court below shall do well to decide the issues in accordance with the law.
Item 20.
Regarding head to the position of law as discussed above, I am not inclined to agree with the view of the court below. The court below ought to have decided the application of the petitioner on its own merit instead of dismissing the same on technical ground. Hence, the impugned order dated 5/3/2024 passed by the learned additional session judge Hon'Ble in criminal appeal number 4 of 2024 is set aside, and the petitioner is granted leave to move a fresh application before the court below under section 457 CRPC. If such application is filed before the court below, the same shall be considered on its merit. Accordingly, it is allowed.
21.
In my considered view, the reasoning given by the court below while rejecting the application suffers no legal infirmity, and it is also important to mention that the court has already fixed a target to conclude the trial. Therefore, the attempt on the part of the petitioner to prolong the trial should not be encouraged. Therefore, the learned trial court should proceed with the matter without further delay to conclude the trial as per the target fixed by this court.
22.
Only thing, my lord, my name is not probably, on the list it is not reflected. I think it is judgment.
Just wrote it,
I'm appealing for the OP number 2,
opinion about
complainant.
wrote it down in that matter. Item 21, na?
21.
21, na?
21.
21. Just note it. Okay. The contention raised by the petitioner in the present petition has been well answered by Mr. P.K. Maharaja in his written note of submission. It emerges from the contention raised by both the parties that there is an FIR already registered in pursuance of which the seizure has been made in compliance with the provisions of 102 CRPC. Freezing of account of the petitioner has already been intimated to the judicial magistrate. The investigation of the case is still on. It appears that there are 66 complaints received by the investigating agency, and the investigation is still on. So far, the fraudulent transaction of 43 crores has come to light. Therefore, I am not inclined to accept the argument of the senior counsel appearing for the petitioner at this stage. Accordingly, I am not inclined to entertain this petition. However, suffice it to say that since the petition was filed at the very threshold when there was no information available to the petitioner except the impugned email addressed by the opposite party number 3 to opposite party number 4, the petitioner is granted liberty to move fresh application before the appropriate court in accordance with the law. If such application is moved, the same shall be considered on its merit.
My lord, they have now not served us the written submissions, the state government. Kindly, that may be asked. A copy of the written submissions filed with in this matter.
They haven't solved.
They haven't served.
Give a copy, Mr. Tel. Because you said that there is no FIR. Now there is an FIR, 102 is compliant and everything is there. Everything is placed on record. Yes.
Could it 22
Yes.
judgments delivered by NRC in a single day?
My lord has
Yes.
worked hard during vacation.
Vacation, utilize the vacation.
And I may pardon,
Yes.
it's a small prayer, my lord.
Yes.
A revision against conviction, 138 NI Act, revision of the year 2013. I am appearing for the complaint. The Hon'Ble Court has directed the accused while granting stay order to deposit the amount, but they have not completed it. For hearing any date, my lord, I leave it to
So
my
that's the
Revision
pending-
against-
revision is pending here.
revision pending before one.
He has not deposited. What is the check amount?
Check amount in one case 9 lakhs, in another case 14 lakhs. Same accused. Yeah. I leave it to my lord. Any day.
Notice was issued already.
My lord, I am appearing for the complaint. Notice was issued and the
Who is appearing for petitioner?
Mr. Prabhas Jena.
You inform him.
Yes,
I list it on Monday.
yes, my lord.
Huh?
I will inform.
You inform him
Yes,
so that either we will decide here or send it to mediation and pay the money and finish it up.
And he is not able, because I have requested Mr. Jena for many times.
Hmm.
His client is not responding. He has told me matter will be listed.
Then see, if you send him to jail, you are not going to get anything. Whatever he is paying,
I
take
consider,
it and
I consider
best
that
for
if
you.
I get my money, my purpose will be served.
Let us see Monday.
Ah,
Tell
Monday.
him,
I sir.
Monday,
Pardon, my lord, modification of order, my lord.
tomorrow. Tomorrow.
Well,
Any mentioning?
Item 23.
Any mentioning? They have some mentioning.
Pardon, Lordship, BLAPL number 3490/2024, Your Lordship. This is the matter was disposed on 17/5/2024. But the order was not uploaded in the High Court site, neither the certificate copy was issued, Your Lordship.
What? Why 17th of May? To me,
I have the,
somebody's liberty is concerned. You can't.
I have written the only number.
Check it up and please report why it is not. I'll just verify.
Yes, Your Lordship.
I mean, pardon, my lord, today's item 26 and 28 may permitted to withdraw, my lord.
Yes, 26 and
28.
28. Withdraw.
Wanted to mention, item 24, your lordship may kindly adjourn to 2 weeks after.
Why, madam?
Item 24 also.
24.
Item 24 is coming for the first time. I'll also obtain instruction minutes.
The joint request leaves the matter on suggestion.
24.
20.
24. Revision against order rejecting discharge application.
Joint request I am.
Yeah, yeah.
Yes. 23?
23.
May I please, my lord?
Yes.
The appeal has been filed by the appellants, challenge the order of confiscation passed by the learned authorized officer,
Hmm.
Bhubaneswar Mala.
Hmm.
The petitioner was facing trial under section 13 to 13(1)(e) of PC Act,
Right.
and the trial court has convicted the appellant. Page 19, para 6.1, judgment,
You
and
have been convicted.
convicted.
Okay.
Then the learned authorized have also dealt with it. And the DA amount 22%, and he has written 6,84,000. My lord, page 19 of the order passed by the learned authorized officer.
19, huh?
Page 19 of the trial court judgment.
Now, which page you are referring to?
Page 19 of the trial court judgment.
Your paper book.
Paperwork, I am pardon.
You have only filed the judgment dated 20th May 2024.
My
That's
lord,
all.
no, I may pardon, I am coming to that. Page 38, my lord.
38.
Page 38.
Okay.
In the, my lord has gotten, or extra copy of it.
Yes.
My lord has gotten,
Yes. 38 I got. Yes.
Page 9, in the present proceedings, since the learned special judge, after thorough analysis of oral and documentary evidence, has laid in his judgment dated 24/7/19 exhibit 60 that the OP number 1 during the check period, that is between 1187 to 1112 acquired movable and immobile assets dispersed to his non-serving to a tune of rupees 6,84,000. It is necessary to open this proceeding to give a finding in that regard. Also, the learned authorized officer has to hold that amount. That the, I will kindly have a glance.
No, during the check period between so and so, had acquired immovable assets disproportionate to his known source of income to the tune of 6 lakhs.
6,84,000.
84,000. Necessary and open this proceeding to give a finding in that regard. Yes.
But the learned authorized officer has hold that amount also. Page 61, page 61,
Page 61.
my lord. My lord has.
Yes.
Movable balances then rupees 6,84,486.
See, where grand total were movable.
Movable.
Plus immovable.
My lord,
Which column? Acha, six,
Or-
no, yes.
6,84,000.
Yes.
So the DA amount is as held by the learned special court as well as the learned authorized officer, that will be rupees 6,84,486.
Hmm.
But the learned authorized officer wrongly has calculated present upward balanceables, that cannot be.
Mm-hmm.
My lord, in page 61,
Mm-hmm.
my lord will find present upward balance available in the bank and other deposits, rupees 1,07,66,431. That can,
What do you want to say?
my lord, that will be taken, I pray, my lord, the confiscation cannot be done beyond the.
Beyond 66 lakhs.
6 lakhs.
That's what you want to say.
That's my lord.
Because
And-
there is a finding of
The
the
long time.
court is disproportionate is to the extent of 6 lakhs. So
Another
therefore,
thing, my lord,
no confiscation can be made beyond that.
number one thing.
Yes.
Number two, my lord, the certain amounts, the income of the certain salaries have not been taken into account. The income of the son and daughter-in-law, that has not been taken into account. And also,
The trial court has taken an account.
trial court has held this but not calculated. And also, in this authorized officer, strangely, he has, though held in the judgment, beyond the check period, certain accounts were taken out. That cannot be. So it will be admitted, and
You are working as what?
I am working as soil conservation,
Huh?
soil conservation officer.
They are very rich, sorry.
Properties are high. Properties are high.
Very, very rich.
In Nayagarh district.
1 crore.
One present.
Madam, that is the provision under the Odisha Special Court Act
Yes.
itself. Section 15, subsection 3 proviso says that market value to be computed. And so far as the already been convicted for 6.
But what he says is,
Yes.
the convicting court says that the disproportionate asset is to the tune of 6 lakhs.
6 lakhs.
What he says that beyond 6 lakhs you can't do.
Yes,
What is the position?
his submission. My lordship, my submission is so far as Odisha Special Court Act is concerned, it has been clearly stated in section 15 subsection 3 proviso that provided that if the market price of the property confiscated is deposit. So market price means present market value of the property. Market price. Not the price which has been determined at the time of seizure.
That time also you
My
might
lord,
have
that-
taken
that-
market price.
Yes, at that point of time, it was the valued assets by the IO.
Which year
And-
that
yes.
FIR?
And but the value of the, suppose the value of the house or value of a ornament, whatever that may be the assets which has been, my lordship, acquired illegally, that ill-gotten property. And when it will be decided at present, my lordship, when confiscation proceeding is terminated.
Say,
or-
when the FIR was lodged and when the confiscation.
Yes.
What is the difference?
Yeah, if- my
Market
lordship,
value, that market value might have been
my lordship,
considered by the trial court also.
FIR is in the year 2005
Hmm.
and
Confiscation proceeding?
and confiscation proceeding was decided in 2024.
No, initiated.
Initiated in 2013. So, my lordship, that is the
5
provision.
and
That,
13.
that is the provision, and this honorable court, honorable Supreme Court has already decided in a case, my lordships.
Do you have any judgment to support your case? Otherwise you don't have because you are convicted now.
My
Do you
lordship,
have any judgment to the effect that once you are convicted and the trial court gives a finding that the disproportionate is to the extent of 6 lakhs rupees and the confiscation can't travel beyond 6 lakhs. Do you have any of it?
That authority, no. But this.
but I will give the
I'll
decision.
simply issue notice, get the judgment.
My lord, I may pardon, my lord,
Yes.
one thing, my lord. Yes. This is statutory appeal. If
I'm admitting it.
unless the matter will be stayed, I,
How can I stay? Because see, the
No.
very purpose of the act
No.
is defeated if it is stayed.
No, no,
I've
sir.
seen,
if it will not be stayed, they will confiscate my properties. That is the act and the
I'm putting it next week, you come with judgment,
Madam,
and decide it.
interested till then, I will come with the decision.
Within 1 week, will they take it?
Yes, madam. Yes, madam. Even if I should not tell, even if the learned authorized officer has not, though appeal period is 30 days, appeal is the continuation of the suit. She should have granted time, but she is not waiting for that. Even if yesterday,
But take it from me that even if I stay it, but I'll fix a date, no
Oh,
adjournment.
yes, yes,
No adjournment.
yes, ma'am.
Take it.
Yes,
Appeal
ma'am.
repeated, impugn order dated 20th May 2024, passed by the authorized officer, Special Court Bhubaneswar in CC number 19 of 2013, is stayed till next date of hearing.
Yes,
In the meantime, let the counsel for the respondent will file the written submission, and the petitioner also shall file written submission not exceeding 10 pages. 10 pages. Leaves the matter for final disposal on date given. Written submission you give it.
Yes, yes, madam.
But I may pardon. 24th one death reference. 24th.
Let him give a date first.
No, no, it's
Yes.
July.
July only.
July last week, July last
July.
week.
No, no.
Give a date. Give a date. No adjournment shall be
No,
given.
man, I will prepare in the meantime.
29th July.
29th.
Madam, I may pardon.
Hmm.
Because some vigilance.
Yes,
tells-
yes, you go.
I am verifying. One second.
Yeah, yes. Don't send your junior for adjournment.
No, no,
Look
no.
at this.
No, my lord knows. I am every day I am mentioning for hearing. I am ready for hearing.
Yes.
Yeah, 29th, 20th, 30th. 20th
30th.
Monday, not session.
29th or 30th?
30th.
30th.
Get
Get some judgment in that sense.
Yes, madam. Yes, madam. I will. And I may pardon one thing, madam. Small prayer.
Yes.
Urgent copy in course.
Yes, yes.
Urgent certificate copy in course.
Yes.
My lord, my name may be reflected,
Yes.
my lord.
Definitely.
Mr. Srimanta Das, Senior Standing Counsel, Vigilance.
But in the meantime, record be called for.
First,
Record.
Record is appeal record is to called for.
Take it. Yes.
Oh, please.
Item 25.
Copy also not served, my lord. Cancellation bill,
21. Copy not served.
my lord.
What is this matter?
Cancellation bill, my lord. There is also defect, my lord. Copy not served on the state council.
The bail.
Cancellation bill.
When the bail was granted?
Copy not.
25.
25, na?
They have not served.
Thing is
even.
filed. Inspector in charge. Give our copy. Pass over, give the copy. Police station. Give the copy. I am passing it over. Just check that. Yes. 26.
26, wait on.
Will
27.
defect. What is this matter is about? Give our copy.
Cancellation bill. My lord, here, my lord, copy is there served.
Is it?
My lord, given the copy.
Yes.
21
Yes,
here.
Mr. Yadav. Not audible, just check it out.
Cancellation bill, my lord.
One minute, somebody is appearing, Mr. Sachin Yadav.
Let them not be party.
You are not audible. Just check it up. You can hear me? Just check your apparatus.
Unmute person. Absent, absent.
What is the problem? From our side? Or?
From their side, my lord.
It seems your apparatus has some problem. Just check it up. I am passing it over. Okay, just check it up. Okay, next.
29.
May I please, your lordship?
Yes, you are there. Yes, yes, ma'am. What is this matter about? Cancellation of bail.
My lord.
Yes.
When the bail was granted? May 2021.
Yeah.
The offense is, you have copy?
Yes, copy में my lord. Though notice my lord issued to OP2 my lord. 1/10/2021 my lord.
498 302 is the husband. What is the stage of the trial?
Yes. In my
498 304B 302 34 IPC. But the charge sheet sometimes 498 304B 306 34 IPC section 3 4 of the DP Act my lord.
302 is deleted.
My lord.
Is deleted. And
Right.
304B
306.
306. Custody, he was in custody for how many months or whatever? Custody since 13/5/2020, and bail was granted on after 1 year.
No matter what happened in this case, my lord. Actually, my lord, during pending of the bail application before this one, my lord, he has moved the before court below and got the bail. Sessions judge, my lord, and there are delivery giving certificate appended on the said the bail petition that the effect that no other bail application relating to the present incident is pending in any other court. For that suppression of the fact.
Suppression of fact.
For that is notice issued, my lord, and on 1/10/2021, my lord.
Lord Counsel, but the petitioner pointed out from the order dated so this is that the certificate was appended to the bail application to the effect that no bail application relating to the incident in question was pending. The court, including the court, Counsel for the petitioner submitted that this is a false certificate given in the bail application.
The requisite file or not, that is, my lord. One, my lord, the mention noting is that a copy not served. But I have got, they have served the copy on the State Council. Perhaps, my lord, no, they have not filed a requisite for that reason. Nobody is appearing for the.
You have not filed requisites also.
I think, my lord, that
Yes,
is.
my lord, I have filed.
But
The service permission the Quran.
Jaiji not.
Anybody entered a period?
Nobody, my lord.
Just verify it. We'll cancel it.
Only suspension of fact, madam. Pendency of the
Cancel it
bail action
and,
before this
allow him
court,
to-
they have suppressed the fact and obtained bail from the lower court, madam.
Then allow him to move fresh application.
That is their slogan given. Suppression of a fact, madam.
Suppression of fact.
Paragraph 4, my lord. Of the petition.
The present petition is filed by the informant. You are the informant. Yes, madam.
Yes.
Are you ready or not?
No, sir, I haven't gone through it.
Shall I put it tomorrow?
Yes.
Tomorrow. I'll cancel it.
Obliged.
But get ready and come. At least you should assist. Yes. Tomorrow.
Item 30.
My lord, item number 30, I am appearing through VC, my lords. My lord, may I kindly pass over this matter, my lord. Mr. Roy would be assisting your lordship in this matter, my lord.
Who is appearing?
Mr. Roy, my lord. Mr. Ajit Roy, my lord. My learned senior.
Acha, pass over.
Gratefully.
I'm appearing on behalf of the OP number 2, my lord.
Okay, he's asking for pass over.
It will be taken up 2 p.m. lordship.
No. 2 p.m. I think the board will be discharged by that time.
Yes,
Pass over immediately after second call. Yes.
31.
Your lordship, the matter has become infectious. The petitioner doesn't want to proceed with it.
Counsel for the petition submits that matter has already become infectious. Accordingly, the petition is dismissed. Again, yes.
32.
Obliged, ma'am.
32. Cancellation.
My lord, state, my lord. But here, my lord,
You have filed.
my lord,
Yes.
what happened in this case, my lord? The subsequently, while the son granted bail, with condition he will not terrorize and threaten any of the witness, my lord. And condition shall not make any contact or terrorize the victim or the prosecution witness in any manner. Violation of the condition shall expose him to forfeiture of the liberty, avail pursuant to this order, my lord. Subsequently, my lord, some cases, my lord, instituted, 2 cases instituted against him, my lord. Since he is given threatening, my lord. For that, my lord, notice may be issued to my lord.
Issue notice to
Opposite
party. Returnable within 1 week. 1 week. Next week. Requisites. Upon requisites file.
My lord, state file.
Without fee.
But yes. But may I be pardon, lords, item 29, lords, I am ready, lords. If your lordship will accommodate to tomorrow, my lords. But tomorrow I am some problem. Item 29, my lord. I am ready. If your lordship.
Yeah, 29, what happened?
That case, my lord, the suppression of fact, my lord.
Good.
Yes.
Yes.
You are for whom?
I am for the lords, the victim, lords.
Yes,
For the informant.
service is complete.
Yes.
Basically.
Yes, lords.
Where is the separation?
Lords, suppression is with regard to lords that in the certificate, lordship, kindly. Your lordship is very the last order, lords.
Yes, last order is all right, but show me the separation part.
Lords, suppression part is lords.
He has to file the bail application, my lord, filed before the court below. That he had not mentioned anything or not filed any memo.
While a bail application was pending before this court,
My lords.
he went there and moved an application saying that no case.
No case is pending. Yes, my lords.
And got the bail.
Yes.
That's the
To
case.
that effect, my lord, some my lord, he has to show something, my lord, that he has not given the certificate or my lord not filed any memo before the court below. That is not there.
Not there. It is there, no?
Because see, cancellation of bail is a serious issue.
Yes, my lords.
So therefore, at least show me the petition filed by him before the court below.
Yes.
Where is that petition?
Whether the certificate given or not, my lord.
You have not filed any petition.
Yes, I have. Lords, if your lordship will grant me, permit me, lords, I will file within a week, my lords.
Even if sometimes they have filed,
because
and sometimes they have filed a memo, my lord.
Memo also, you don't know.
No, lords, not prior to that.
On the basis of your oral statement,
Yes, my lords.
the coordinate bench has written
Yes,
that he has suppressed the facts.
my lords.
You have not filed the application moved by the accused before the
Accused.
court below.
Court below, my lords.
Show me the application where he has said what.
My lords, just now it is not with me, it is with him, with my Lord, my lords, friend. It is my friend's file. It is with him.
Oh,
He has not come. Your lordship, kindly call next week, my lords, I will.
Next week.
Yes, my lords.
Monday, Tuesday.
Yes, my lords.
Come and satisfy me
Yes,
that
yes. With regard to that,
in fact he has
Yes,
suppressed.
yes,
I'll
yes.
cancel it.
Yes, my lords. In the order sheet, it has been written, but if I
Order
show
sheet,
the in the
this court order sheet.
yes, my lords. So in the law,
Because this court has recorded according to your oral statement.
my
Show me any document.
yes, my lords. So in the two things will be satisfied because if the order of the London court below the sessions court as well as the petition therein.
This court earlier proceeding has no
Yes,
meaning
yes.
unless you show me.
Yes, my lords. Okay.
Yes.
33.
33.
May please, your lordship, my lord. Cancellation of bail, my lord. Lordship, the anticipated bail was granted, subject to condition, my lord.
What condition?
Lordship, can you go to page 4, my lord. Condition I have jotted down. That is reflected in this order also.
Yes.
In the lower court order, but they were granted bail in page 41.
Here is the case, my lord. Earlier, the Honorable Court directed the State Counsel to obtain instruction regarding subsequent status of the subsequent case, my lord, instituted against the accused, my lord. That is not with me, my lord. Another date may be given, my lord.
Next week?
My lord.
Next week. When the bail was granted?
My lord, bail was granted. See, 21 9 2000.
22.
42 page 42.
22.
21 9 2022.
What is the stage of trial?
No, I am not also taking instruction.
Just see whether trial is concluded or what. The 2-3 years the bail has already been granted. Why to cancel now?
I'll take also instruction to that.
Let's figure out.
34.
By cancellation of bail, everybody is filing.
Obliged, sir.
Non-appears for the petitioner and the matter was called off. This is an application under section 439(2) of CRPC seeking cancellation of bail granted by the Learned Additional Sessions Judge Patnagar by its order dated 20th July 2023 in BLAPL number 2790 of 2023 in connection with the Sessions case number 9 of 2021 arising out of a GR case number 390 of 2020 corresponding to Belpoda PS case number 96 of 2020 for offenses under section 302 IPC. Filed by the informant.
Just foreground matter, 13 witnesses, but they have not filed any document with regard to that.
The matter was listed on 4/1/2024, 18/1/2024, 31/1/2024, and 21/2/2024. The learned counsel for the petitioner sought time to cure the defects. Thereafter, on 18/1/2024, none appeared for the petitioner. Again, on 21/2/2024, none appeared. When the matter is called up today, again none appears for the petitioner. In view thereof, the petition is dismissed. Next.
35,
Even the possible place one.
Yes.
36,
Cancellation. Cancellation bail matter.
Yes.
Your Honor, I have filed application for cancellation of the bail of the opposite parties number 2 to 4 matter. On the ground matter, can I have a glance to the FIR matter? FIR, see, it has been the offenses are 341, 294, 323, 25, 506, 34 IPC matter. Now, matter turn to Cognizance matter. There, the learned court has observed like this matter.
Yes. They shall not commit.
No,
similar
that is the observation.
Yes.
Before that, my lord, he has taken the cognizance
Under sir 326 Act.
326, my lord. 326 is admittedly a higher offense.
Life.
And yes, my lord. And which also attracts a major penalty. And over here the present petitions were on police bail, which the police cannot grant under 41. But the court has taken care of because of the fact that they have been granted police bail, the court has granted.
What are the injuries?
Injury, my lord, I have filed. Let me see at page 15. Grievous injuries, my lord.
Grievous injury 307, we have been granting bail.
No. My lord is granting, but I don't dispute that. But the magistrate, my lord, my humble subject kindly appreciate. The police has initially granted them a police bail. So in I'm giving an example of subject appreciation, my lord. In a small case like 307, suppose my lord has granted the bail. The moment the case turned to 302, that means a higher offense added. The bail will not automatically flow on. It is earlier with the view was that once a person granted bail, it will continue till the last end, my lord. Now the view is there, once a person has been granted bail and subsequently a higher offense has been added, my lord, the bail will not automatically go on. The concern, because the consideration at the first instance because of the offenses and the last.
The bail is granted by a court.
Police.
No.
Police, my lord.
Where is that bail?
My lord, see. Below the case record, the accused in such and such. So accused filed a memo on, okay, is on bail on this case by this court, even if by humble servant, even if by the court also, because the consideration, once it was granted bail when 325 was there, lesser offense, now 326. The bail will not be automatically granted bail.
Then they have to apply that the only technical thing. Okay.
Yes.
Small technical.
They know, not a small technical. Here, because of the offense and the prescribed punishment, they are
Higher offense.
Yes.
Higher offense is added, then that what is that Agarwal?
Sushil Agarwal.
Sushil Agarwal. Sushil Agarwal.
No, not it might see that particular judgment. It is also stated that no, because when the higher offense will there, the consideration.
Prabhakar something.
The consideration will
Sharma.
my lord,
Pradeep Sharma.
the consideration will be automatically not different, my lord.
What is the stage of the trial?
Just now granted bail, my lord.
Let it be bail granted.
It requires a consideration.
You appear for accused every time you.
I'm not on that. My humble source, I am not on that because
it's a matter of bail. Forget about the gravity of offense. Somebody got the bail, let it be.
No, even if my lord, they will be granted bail because of the fact that the landed court below has not considered the fact that the higher offense in the man, because the same court has taken the cognizance. The same court has taken the
Don't
cognizance.
bring technicality into it.
No, it's not a
Bail has
technical
been
matter.
granted.
My humble
He has
submission-
not been acquitted. Bail has been granted.
No, no.
Let it be.
No, my humble submission, when a consideration is there, and with this, my lord, kindly appreciate, this honorable court also, day in and day out, when this.
Simply I'll issue notice. Issue notice.
Yes.
I can't cancel it
All
in
right,
any
all
case.
right.
Issue notice.
Liquidates by day after tomorrow, within 2 days liquidates.
You have to serve him.
no.
Accused. Bail has already been granted. Without serving, how can I do it?
No, as my lord, issue notice, I have to file the liquidates to send them.
You file within
Yes,
2
ma'am,
days.
within 2 days.
That's what I'm saying.
Ma'am.
File it.
Ma'am.
Put it.
I'm pardon.
Yes.
Item number 35. They have taken a pass over. After lunch, I will not be available.
Do you think that this board will remain till lunch? I think we will be. Anyway, 35, na?
35. I would then ask cancellation of bail.
Asuntu, korda it. Asuntu. You come.
More as more to
Okay.
opposite party.
Who is?
Mr. Bose.
Boss.
Huh?
Boss. They pass over.
That case, my lord, 409, offense 409, the London Court magistrate granted bail. And he, since he stated that, since the offense is.
Maybe it is regular bail.
Bail has been granted. Why unnecessary in the bail matter?
I would then ask again if they are interested.
I'll put it tomorrow.
Okay.
This means what is this bail granted? People are struggling to get bail. Somebody is getting bail and you are. Yes. Jail रे जगह नहीं. खड़े हो पड़े उसमें. Right. Tomorrow. Yes. Yes. 30. Yes.
But probably my learned friend appearing for OP number 2, he is not there.
Yes, my lord, I am here.
He's there.
He's there.
Yes, ma'am.
Passover was short on your behalf.
Yes, ma'am. Yes, ma'am. But
What is this matter is about?
it's regarding cancellation of bail.
What
Under
is the offense?
439(2), my lord.
Offense?
Offense is of under section 420. If lordship kindly see the last order, there was a direction to the state to take instruction as regards to the FIs registered subsequently, my lord.
In one case, my lord, during course of investigation, the case was ended with the final report, my lord. That is, there are 2 cases, my lord. One case I got the instruction, my lord. That is Noyapalli PS case of 92 up to 2023, my lord.
Subsequent to the
Subsequent to this case, my lord.
bail, huh?
One case, my lord, the final report submitted, my lord. And another case, my lord, is Borough, that has not been come, my lord. I have not obtained any. So far, the Borough PS case number 420-23, my lord. One case I got the instruction. That has
Where are the bail conditions? Let's see. Where are the bail conditions?
Bail conditions, your lordship may kindly see at Annexure 1, page 11.
Yes.
Page 16, my lord.
Yes.
He
shall not
Huh.
commit similar.
Yes, my lord. My lord, being fully conscious of the parameters of cancellation of bail, my lord. My lord, the petitioner is a retired government doctor, my lord. He is a scheduled caste. My lord, he has been duped of his legitimate dues, which he had earned over a period of time during his tenure, my lord, as a government servant. He invested his money to purchase the land. My lord, the agreement to sale which was made, my lord, says that the accused is the owner of that plot. Subsequently, my lord, the petitioner finds out that that land does not belong to him. But this is nothing but a clear case of cheating, which and intention was that to cheat from the very beginning, my lord, from the very threshold.
Agreement to sell or?
There was an agreement to sell. Your lordship may kindly see the agreement. I filed a rejoinder.
Has he given a declaration that I am the owner?
Yes, my lord. So now, my lord, within a span, the FIR was registered on 26.
What is the due diligence you have undertaken?
My lord, obviously, my lord, let the buyer beware, my lord, that concept is there. But over here, my lord, your lordship would
You are
see.
purchasing. Somebody says that I am the owner of Lal Killa. You enter into agreement.
That is
without
true, my
due
lord.
diligence.
My lord,
Thereafter he gets the bail. Then
no,
how?
no, my lord.
How?
Now, my lord, I'll just, my lord, first of all, my lord, this case was supposed to be argued by Mr. Yashwant as well, because the old-time friend of him. So I didn't want to take the risk over my head, my lord. But
these are the big
no, my lord,
matters. Ultimately,
your lordship would, I'll
2021
yes,
you got
my lord. I'll bow down to whatever your lordship says. But 26/7/2021, the FIR was registered. But the FIR was registered pursuant to a complaint filed by the present petitioner, my lord.
I am not into
My lord,
the merit. See, the only condition
yes, my
is-
lord.
See, according to me, my personal view, these while granting bail, passing an injunction order is also not permissible.
Yes, my lord.
These are kind of injunction orders. You
Yes,
will not
sir.
indulge in. How can you pass injunction order like this? If a criminal is there, he will do it, and it will be dealt with in accordance with law. These
My lord,
are the conditions. Are
my
neither
lord,
here
one
nor
of the
there.
one of the consideration for cancellation of bail is also the perversity of the order. But I'm strictly on that, my lord. Your lordship would see 19/11/2021. FIR was registered in the month of July, 26/7/2021. 19/11/2021, the accused was arrested. 30 within a span of just few days, my lord. 30/11/2021, the accused was set at bail.
What
My
is the
lord.
stage of trial?
Trial, my lord, it's yet to begin, my lord.
So, charge has been framed.
Most likely, my lord, charge sheet must have been framed. I'm not aware of the thing, but your lordship may kindly see the impugned order. My lord, Honorable Apex Court has also said that bail,
What is the incident and antecedents as per your instruction?
as per my instruction, my lord, I could not find out any antecedents, but it was the bounded duty. But my lord, within a span of just few days, he was granted bail when the investigation was at the nascent stage. And your lordship may kindly see the observation. And Honorable Apex Court has said that one can form a prima facie view, but one cannot enter into the merits and demerits of the case. And that is exactly what the learned lower court has done. Your lordship may kindly see Annexure 11, Annexure 1, my lord, is the order.
Yes.
My lord, your lordship may kindly turn to page 14. Internal page 4, page 14, running page 14, my lord.
Exactly.
The last paragraph.
Yes.
Peruse relevant materials available in LCR. It is alleged against the accused petitioner that the accused petitioner, after taking some amount from the complainant, executed an agreement with him to sell a piece of land measuring 10,000 square feet in his favor on receipt of full consideration amount of 33,50,000.
How much you have paid?
I have paid 21,96,700, my lord.
It is judgment in case of the complainant.
It is admitted case of the complainant that he is paid a sum of rupees 21,96,700 in total. The accused petitioner at different phases under different modes in the year 2010. Subsequently, the complainant has not paid any amount to the accused petitioner. It is clearly mentioned in the agreement executed between the accused petitioner and the complainant that the registration of the plot.
Without any due diligence, what kind of?
My lord, that is a, my lord,
Yes.
nowadays, my lord,
Yes, Mr. Parida.
Yes,
why
madam.
shouldn't they return that money?
Why don't you return the money?
Lordship, what happened? Kindly have a glance to the agreement which has been cited by my lord and senior brother. In that
Have you
agreement,
taken the money or not?
Lordship, I have taken the money to the tune of 20. Yes, Lordship, I have received that money, but he has not the penny as per the money as per the agreement. Even if so far as the agreement has been cited by my lord and senior brother, it clearly specifies that by the strength of the agreement with several owners of the land situated. Nowhere it has been mentioned that I am the owner of the land. I have entered with some agreement with some of the landowners.
You forget about everything. You have taken the money, you give it back.
No, Lordship. I have also registered another land in favor of the present petitioner, my lord. One of my brother,
That is false. That is a
No,
different piece of land,
that-
different consideration amount has been paid.
In lieu of the same payment, he has given you another.
No, my lord, that is false. In my rejoinder, I have brought it. He is trying to mix up things. That's a different issue altogether. And in fact, I had been to RERA. RERA has passed an order in my favor, asking them to return this money with interest.
So why don't you return the money and finish it up?
No, man, I have also, Lordship, due respect to my senior
And
brother, this is a partnership firm. And we are two brothers who are the partners of that partnership firm. And one of my brothers has executed a sale deed in favor of the present petitioner. And so far as the RERA case is concerned, besides the RERA case, several other cases are also pending. Even if Lordship, so far as the criminal antecedents are concerned, if your Lordship will peruse the rejoinder of the present petitioner, it clearly transpires that all these cases have been clearly fabricated against me. If your Lordship will permit 2 minutes, I will prove before your Lordship that how the cases have been fabricated against me, Lordship, in both the cases. It is very unfortunate, Lordship.
If it is fabricated by the order by RERA.
No, my lord. Kindly have a glance to the affairs, Lordship. In both the affairs which have been cited by the present petitioner, my lord.
I don't. You withdraw it, reserving your right to do whatever.
My lord, may I pray for one thing, my lord?
Yes.
Yeah. I was looking for the. My lord, your lordship may at least keep it to first week of July, my lord, because he's a friend of Mr. Das. So Mr. Das is also aware of the law.
First week.
First week of July. Grateful.
But you think of what to do now. Because you are prosecuting.
But every day in and day out, we argue cases for bail, my lord. So.
See, there are a lot of complication and lot of complicated facts in this scenario. Somebody is getting bail.
No, I'm on the perversity of the order, my lord. The learned court below couldn't have gone into the merits of the case.
The superior courts should be loath in interfering in bail matters. See, the problem today is, you must understand, the problem today is the trial courts are reluctant to give bail, as a result of which the high courts are overburdened. The high courts are also reluctant to give bail. Supreme Court is overburdened. The constitutional courts has become a bail courts. This is not the object of the Constitution. And all these things should have been done by the trial court, which we are doing. We are not bail courts. We are constitutional court. We are supposed to decide constitutional issues and matters. But what we have turned the high courts and Supreme Court to the kacheris because of this attitude. So we have to be, we have to think in that perspective. So therefore, we should be loath in interfering in matters where the bail has been granted by the trial court. And indirectly, we are discouraging the trial court for granting bail. In interfering in every matter. High court shouldn't interfere. Once bail is granted by a court of law, and that too in offense like 420 and all, why should we interfere? We should encourage the trial court to more proactive in granting bail.
At least, my lord, a condition have been put so that at least they should deposit some amount of money.
Tomorrow, this judge who is granting bail, he'll say that why should I grant bail if the high court is interfering in granting bail? So then what we are doing? We are doing a disservice to the system.
No,
that's the idea. That's the whole idea. I'm not saying you are case.
No, my lord.
That's the whole idea.
My lord, substantial justice can be done, my lord. At least if a condition is imposed, then let them deposit 50% of the amount with the court.
You can very well go to the trial court. I'll relegate you to that extent.
Your lordship, because 439(2), my lord, lordship exercises the same power with that of the sessions court.
Condition, you can very well say that I'll say that I'm not interfering, but giving you a liberty to go to the court below for variation of the condition in view of his conduct.
My lord, instead of that, my lord, if your lordship would direct, at least, my lord, subject to the result of the trial, let them deposit at least 50% of the amount.
I don't know. He says that one land is already registered.
No, my lord, that is the subject matter of the trial, my lord. That is the subject matter. Ultimately, whether he is guilty or not guilty, my lord, that will be decided by the trial court.
Corrida, will you deposit something?
No, lordship, I have already, even if he is, he has to discharge some due in my favor, he has to pay some money to me. So far as the cost of the second land is concerned, lordship.
Let it come on 1st of July. First week of July.
But I am making it very clear. I am not interfering
okay.
in any matter where bail is granted by the trial. This is very
And
clear.
there may be a special case or different case where your
Different
lordship.
case, I will modify
Yes,
it
sir.
here and there a little bit, but I will not
Yeah.
interfere.
Dateful, my lord, first week of July.
First week. At the request of Mr. Can I just come within two minutes? If you don't mind, I'll just come.
Accommodation, your lordship.
What is this matter is about?
So it's a cancellation of bail, your lordship.
Bail granted in March 2020.
Your lordship, on a misrepresentative fact, your lordship, that they have been submitted, that there is agreement or settlement between parties, your lordship.
Suppressing that fact, they have filed another bail application and they are obtaining the bail order. Notice.
Within 15 days, your
Madam,
lordship.
we did not notice. Earlier filed anticipated that has been rejected, madam. Suppressing that fact, again file another anticipated bail application and obtain the bail order.
Offense is the 307. You have to find out a way how to deal with. See, cancellation of bail is not the solution. If somebody will impose heavy costs for this thing, but we not cancel the bail. Instead of that, better to impose heavy costs.
Nobody will dare to find.
Yes, yes. Cancellation. See, I'll just adjourn it for tomorrow. Let the notice has not been issued.
Notice, madam.
Issue notice to the opposite party number 2, returnable next week. And file requisite by tomorrow.
Your lordship.
Mr. Yadav.
Your lordship.
File requisites by tomorrow. I list it next week.
Your lordship. Oblige, your lordship.
Notice to my lord, OP 2 to 4, madam.
OP 2 to 4. Will impose heavy costs and maintain the bail order for non-disclosure, suppression. Yes.
37. 37, a modification of order, my lord. In the paragraph 2.
37.
Yes, my lord. NBW actually, lordship has it has been rightly written, paragraph 3 of the order, NBW has 10/1/2024. But in paragraph 5, order, your lordship has quashed the order 5/8/2021.
What are you doing?
The order is, my lord, 10/1/2024. That is the NBW. That is also in the cost title and but in the paragraph 5.
Which paragraph? Para 5.
Para 5, it is an order dated 5/8/2000 is set aside. Instead of writing 10/1/2024. Because NBW was issued on
10/1. Just see.
10/1.
Where from you got this order? See on the order dated 30th April 2024 and para 5. The para 5 instead of 5/8/2021, it should be 10/1/2024. Prayer 10/1/24. Where from you people are getting this? I'll keep on checking every dates or what? Hello.
And also extend the date of your lordship directive to appear.
Of the aforementioned confusion, the petitioner could not appear before the court below as per the stipulated time granted to him. In view thereof, the petitioner is directed to appear before the court below on or before July 15th.
Yes.
15th July 2024 and seek the appropriate remedy available to him under.
38 modification of order, my lord.
Yes.
CRLMC 1892 order dated 16/5/24, my lord, paragraph 3, my lord.
3, yes.
My lord, your lordship allowed the petitioner to submit before the learned court below on before 36. My lord, kindly mention the name of the court, my lord. That is, my lord, the Assistant Session Judge Badamba, where the case is now pending for
There is a
trial.
court below. I've said.
My lord, ଟିକେ difference ଏଥିପାଇଁ ଅଛି ଆଠଗଡ଼ ସେସନ ଜଜ୍ ଆଠଗଡ଼ ଏନବିଡବ୍ଲ୍ୟୁ ଇସ୍ୟୁ କରିଥିଲେ ଅଫେନ୍ସ ହେଉଛି 363-66 ବଡମ୍ବାର ସେତେବେଳେ ସେସନ୍ସ କୋର୍ଟ ନଥିଲା ସେତେବେଳକୁ ଟ୍ରାନ୍ସଫର କରିଥିଲେ
Below means whichever is the court.
ମାନେ ଟିକେ ପାରାଗ୍ରାଫ ଟିକେ ଅସୁବିଧା ସେମାନେ କରୁନାହାନ୍ତି
ହଁ, କୋଉଟା କହିଲ?
ପାରାଗ୍ରାଫ 3 ରେ କୋର୍ଟ ବିଲୋ
ଆଠଗଡ଼ ଲେଖା ହେଇଛି।
ମାଇ ଲର୍ଡ ପାରାଗ୍ରାଫ 4 ରେ ପେଣ୍ଡିଂ ଇନ ଆଠଗଡ଼ ଲେଖା ହେଇଛି ସେ ପେଣ୍ଡିଂ ୱାର୍ଡଟା ଡିଲିଟ ହେବ ପାରାଗ୍ରାଫ 4 ରୁ ପାରାଗ୍ରାଫ 3 ରେ କୋର୍ଟ ନାଁଟା ଆଡ୍ ହେବ ଏତିକି
କୋଉ କୋର୍ଟରେ?
ଆସିଷ୍ଟାଣ୍ଟ ସେସନ ଜଜ୍ ବଡମ୍ବା
By order dated 16/5/2024, this court has directed the petitioner to appear before the court below on or before 30th June 2024. However, the name of the court has not been mentioned. Therefore, the petitioner seeks indulgence of this court and prays that his client will be appearing before the which court?
Assistant Session Judge Badamba.
Appearing before Assistant Court
Badamba.
On or before 30th of June 2024.
Extension of time.
On or before 15th of July 2020.
Paragraph 4
and seek remedy available under law.
Paragraph 4
accordingly, para 4 of the para 4
pending
the order dated 16/5/2024 is also modified. Modified and in place of assistant sessions judge.
ସେଇଟା ଠିକ ଅଛି ସେଇ ପାରା ଠିକ ଅଛି ପେଣ୍ଡିଂ ଟା ଖାଲି ଡିଲିଟ ହେବ
ହଁ it is pending.
Pending what para
4 of the order date also is modified in the following manner. पूराटा उठेଇ देबो ये पेंडिंग जो खाइ छै ना पेंडिंग इन दी कोर्ट ऑफ पेंडिंग काट
एनबीडब्ल्यू से इशू करथे
ठीक है सब गुडा रहबो पेंडिंग काट ठीक है बी वेरी केयरफुल पेंडिंग काट ठीक ओके
obliged
please your lordship that's right order dated 28/5/2024 your lordship was pleased to grant me the liberty to approach the learned court below and my NBWs were stayed, my lord. The only predicament here, my lord, is the case under section 302. The SDGM who had issued the NBWs is bereft of the powers. So I have prayed for first hour, second hour to be added with the parity which your lordship had granted me.
My daughter dated 28/5/2024.
28/5/2024.
This court had directed the petitioner to appear before, while cancelling the, staying the, set aside, na?
Yes, my lord. Your lordship had set aside the NBW.
While setting aside the NBW issued against him, directed the petitioner to appear before the court below on or before 30th June 2024 and seek appropriate remedy available to him under law. Let counsel for the petitioner submits that the matter is now pending before the...
No, my lords, the matter is pending before the SDGM. But in view of the fact that co-accused have been granted bail, SDGM is bereft of the powers to consider my application for bail under 302. So first hour, second hour may also be...
Since the present case...
my lords, may I pray? An additional player of first hour, second hour to be considered on the same day on the event of surrendering.
No, where is your application?
Well, my NBW was issued by the learned SDGM.
I understand it, but where is your application? What
are you in IA number 1596.
Learned counsel for the petitioner submits that he would be appearing before the court of learned SDGM, Denkanal, in the first hour, and to first hour and move appropriate application for grant of bail. In the event the application is rejected, the same shall be considered on the same day by the sessions court in the second hour. In view of the in terms of the contention made in the application IA number 1596 contention raises, the application is allowed. and the petitioner is directed to surrender before the court below on or before 30th June so and so, and avail move appropriate application under law. If such application moves, the same shall be considered by the court of STJM, Dankana, the first hour. In the event the application is rejected, the liberty is granted to the petitioner to move to the sessions court on the same day. Yes.
With the principles of parity, we also.
All these things.
That's-
This much I did because you were appearing. If your senior would have appeared, I have rejected. Yes.
Thank-
40. This is not modification, this is adding in the order.
Well,
Modification,
that was the-
if there is some correction, you wanted to add something on the order which was already made. Anyway.
As list of the conditions enumerated in 28 size, that may be also.
Anyway, you get it. If parity is there, parity is there. And
Yes,
nobody
my
can take
lordship
it,
was-
whether I say or you don't say.
The Lordship was pleased to include that in the last
We'll see.
one.
We'll see. Okay, next.
Grateful.
Yes.
Item 40.
If I may please your lordship, my lord, I may be permitted on behalf of Mr. Dwivedi, my lord.
Yes.
My lord, this is an application that has come up for early hearing. My lord, I'm ready with the arguments. If your lordship permits, I can start.
Yes, I'm also ready. Mr. Rijvi has to be there. What do you want?
Just come under the headings of orders. I was of the opinion that it will be taken as.
Seeking early hearing.
In that
I'm
case-
allowing it.
Yes, my lords. In
And
that
when,
case,
when can you be ready? You tell me.
means today let him submit his submissions, my lords. Any other date, I will give the reply and your lordship may conclude the hearing.
Partly I'll hear.
Yes.
Fair, my lord. Yes, my lord.
Let me just run through the list and I'll hear.
In that event, my lord, my lord, after your lordship exhausts the list, I'll come back, my lord.
Yes, that's what I'm saying.
I'm grateful.
5-10 matters are there.
I'm grateful, your lordship.
Yes.
41.
Yes.
May
Yes, madam.
appellant has already been died and I have filed a IA petition for substitution of the widow.
My lords,
Widow.
two IAs have
Die-
been filed.
die-
One IA is 1087 of 24. This is for substitution. And another IA is 1088 of 24. That is for condonation of delay.
Condonation of delay.
My lord,
1087
yes, that
87
is for
is a
substitution.
allowed. 1087 allowed. Both condonation of each also allowed.
7 years is the delay. my lords.
What was
Widow
the
lady-
issue?
widow
More than
lady-
7 years. my lord.
Have you filed any objection to that?
I haven't filed it. If your lordship may permit, I can file it within a week.
No, is there any substantial this thing?
This ground that has been taken, your lordship must kindly see para 4. This
Yes.
is the ground that they have taken for the delay. Para 4 of IA number 1088.
Previous advocate.
Yes,
Yes.
this is the ground. If your lordship consider
This
that as a
fact-
sufficient cause, my lords,
24. When was the appeal pending? 2009.
Appeal is 2009.
2009, my lords. That's
What are the offense?
Offense 13-1, 13-2, read it 13-1E of the Prevention of Corruption Act.
I don't know.
It's a DA case, my lords.
Let's say the widow,
2017.
widow lady, let's say they maybe allow.
2017 death.
Yes,
And you move application?
this
It's
May, my lords. Last month they have filed this application. 29/4/2024. This is what this.
Do you have any case on merit?
Yes, merit.
Hmm?
Merit.
Property is confiscated.
No,
Only the stigma,
Confiscation.
because of the stigma only.
Yes.
Nothing is.
As your lordship, formal objection, your lordship may kindly observe. Allow it.
Allow it.
Yes.
allow.
Allow. Both the application.
Lords may kindly
Will you
observe.
condone it?
But in the limitation petition, your lordship may kindly observe my formal objection. to that.
Your objection. Raise objection right now. Objection.
Grateful.
For the allow.
Paper book already ready, let's say.
Yes, we are in receipt of the paper book. They
Yes,
need to file a,
Then we can hear it.
they need to
For hearing,
file
keep the
a
matter for hearing.
fresh cause title because now your lordship
File
is,
the amended memo party.
yes.
The petitioner filed the amended memo party, leaves the matter for final disposal on video next week, next week video, July the first week video. In the meantime, petitioner and the respondents are directed to file a written submission not exceeding 10 pages. Not that the a petition is 5 pages and written submission is 50 pages.
Lordships are calling this matter the first week of.
First week and get ready.
First
It is
week.
made clear that no further adjournments are given. Come ready and come.
Item 42, my lord, I have received the paperwork, my lord. Let it come next week, any date, my lord, for final hearing, my lord.
Hearing, ready?
Yes, my lord.
Paperwork is served.
Yes, my lord, I have received the paperwork.
Mr. Mishra, the responsible for the petitioner submits that he has already received the paperwork in the case and ready to address the court on merits. Leave the matter. 27. 27th ready, Mr. GB.
Pardon, which date minutes?
27th.
27.
And
This
meantime,
month?
meantime, Mr. Mishra
I will file the written objection.
and Mr. Rijvi shall file written submission not exceeding 10 pages.
Well, can it be in the first week of July, my lord, subject to your lordship's approval?
Then date may be fixed, my lord.
Speak to Mr.
Yes, my lord.
Jyoti and adjust yourself so that
A date may be fixed, my lord.
That's what my lords are saying. Yes.
So the see, many matter if you list for hearing, he may not be ready. So therefore you have to accommodate both the sides. And you just see, you adjust your this thing. And if you are changing the date, please intimate the other side. Then he has to also confirm. Okay.
Deeply obliged.
Yes.
43.
Revision.
Lordship, on behalf of Nalini Das.
Sorry, madam.
NK Das, on behalf of NK Das.
Yes.
Your Lordship, not able to contact with the client, seeking for 1 week time.
Not able to contact your client. What are the offenses?
Lordship.
307. Convicted under which provision? 323.
43
323 conviction. Only one of them. That is Bikola Kumar Das. And acquitted under 307/24 and all. Sentence is first offender. You are released on PO also. What do you want?
Seeking for only 1 week time.
1 minute, 1 minute. It can be allowed. So therefore, I'm Mr.
My scene.
See, 307 charges and they were acquitted, convicted under 323. And the trial court says that provision of offenders act benefit is given. And now let us see the appellate court.
Since defects are not removed for that, it is listed as a orders, madam. We have not solved the copy. For that, it will come, as orders, madam. For orders. And that's defects there, madam. And copy not solved.
1 month, appellate court said 1 month. What are the defects?
Different now 9.
Huh? Different now 9. Madam, you can argue. There is nothing.
I'm not ready, Your Lordship.
Shall I put it tomorrow, day after, Monday? When do you want?
After a week.
Get ready. There is nothing. You will be acquitted.
After a week, any
I
day.
saw, you take the credit of acquittal. You will be acquitted because 323, trial court convicts and extend the benefit of provision of offenders act. Appellate court, what appellate court does is 1 month sentence. And he has already undergone few days. And that is also set up. Nothing. Monday, Tuesday. Tuesday.
Any day, your
Pure,
lordship. after
9,
the-
what is the defect? Copy supply. Supply the copy.
I don't-
Record not, also not with you.
Actually, I have instructed
Necessary correction is made as it is corrected to criminal division.
Get a copy and give a copy to him, and I'm putting it Tuesday. Tuesday. Okay.
Okay.
Tuesday. Yeah.
Item 44.
LCR has come. You can take you get a pen drive and take a copy. Here.
44.
44.
Your lordship, on behalf of NK Das, we are filing wakalatnama.
No.
Yeah, here could be.
Here, what is the offense?
So, lordship.
NIA. Who is appearing for the opposite side? Let's see. Opposite side will give you the
Item 44. On behalf of Mr. Rautare, kindly taken up tomorrow.
Which one?
Item 44.
No, I'm just on
Sorry.
this matter.
Delay, my lord, there are delay, my lord.
No, this matter where she has filed the wakalatnama for petitioner, who is appearing for the respondent? ICICI Bank.
We are appearing.
Huh?
Sole opposite party.
You are for opposite party. Who is for petitioner? BB Rao.
There are delay, my lord.
Delay?
Unless delay has not been confirmed, my lord.
On behalf of Mr. B.B. Rautare, 44.
Okay, you get ready tomorrow. Tomorrow, madam. Get ready and come, huh?
My lord, in this matter, it will come after
You are appearing for
opposite party
40.
matter 44. We have just now filed our wakalatnama. We need some time to file the objection. My lord, he is my associate.
He has filed wakalatnama.
We need,
Okay, get ready tomorrow.
we need some time to file objection.
Tomorrow. What objection tomorrow? We'll see. If the delay will not be condoned, then yes.
Oh, bless.
Yes.
45.
Let's say item 45, I say 1 week time to remove the defect.
No. This is a case, my lords. My lords, they have come up against an order framing charges in a trap case, my lords. And they were caught red-handed, my lords. There are ample materials, my lords, to indicate their complicity, my lords. This case, 1 minute.
Stay operating.
No stay, my lord.
Then what
Case
is
has
the
been,
stage of
the trials begins on 23rd August 2023. If you lordship turn to page 63, my lords, the date 63, my lords, put off on 28/8/2023 for hearing, my lords. Trial begins after the framing of charge, my lords.
But no,
So,
what
my
is the
lord,
stage of the trial? Now,
so I have no objection if they raise any issues, my lord. The essence of their submission put forth in this revision is for reappreciation of evidence on records, my lord. Let them raise any issues before any place, my lords, before the trial.
Now say trial is proceeding. Today you are coming and you have filed the petition. You are not serious, it seems.
Let's say 1 week time.
2023 you have filed. Charge is framed way back in 2000.
23 August 2023, my lords.
You allowed the trial to proceed.
No, already started.
Let's say my senior will argue the matter 1 week time.
August. By the time trial will be proceeding and you will be dismissed.
Let's say 1 week time.
No, not 1 week. Keep it. Yes.
So, fixed to August.
First week of August.
46.
Yes, may I please, your lordship?
Yes, what contempt is this?
My lord, as per the order of this honorable tribunal, honorable High Court, my lord,
And earlier he has moved to the honorable tribunal. The honorable tribunal has directed, and thereafter the contempt has been filed, and this honorable High Court directed to comply with the order of the honorable tribunal, my lord. That the as per the order, my lord, that the entire service period of the petitioner was
Which
not
order?
regular.
Which order you are talking about? By
My lord,
the way,
yes, ma'am, I am
how-
reading the order.
How
ma'am.
this matter has come up before this court?
So moto after so moto contempt, this has been filed, my lord.
Yes.
The OA.
Show me the order which is not.
Yes, my lord, I am showing the in original content, my lord. In the first, I am reading the. Running page 12, my lord.
12. Yes, ma'am. Yes.
Even though an objection is raised,
Where are you reading?
yes, my lord. I am reading in running page 14, my lord.
Yes.
An excerpt document. Even though an objection is raised by learned counsel for the opposite party contemners and the maintainers in the event, the direction issued in this original application is not complied with as of now, the present incumbent is directed to work out the same within a period of 1.5 months. Hence, provided the order of this of the tribunal is not challenged in a higher forum with an order of stay of such order, the compliance report be filed before the registry of this court within a period of 1 week thereafter. Failure of compliance of this order shall be considered to be deliberate violation of this court's order, and there will be initiation of a suo motu contempt proceeding against the contemptor.
Yes, this order was passed on 21/12/2021.
My lord.
When the suo motu proceeding was initiated?
Thereafter, my lord, suo motu proceeding was initiated, and in suo motu proceeding was dropped with a libet.
Has it been initiated within 1 year?
Yes, my lord. My lord, I have mentioned in the everything in the environments, my lord. Here, my lord.
Notice has been issued.
My lord.
Notice has been issued.
Yes,
Who is appearing? Yes, sir.
Have the reply of the order 14/5/2024. 14th May 2024. Also.
You have filed, huh? Shokar?
Yes.
What do you say?
Lordship, have a glance to the page 3, Lordship.
Yes.
There is the para 7. Lordship, have a
para 7. Yes.
Para 7. When the service of the petitioner has already been regularized in a different phase, and financial benefit has also been extended to the petitioner mostly by the appellant's authorities. The salary area
Where are you reading?
Lordship, my rejoinder affidavit filed on 14th May 2025.
Para
7.
7.
Yes.
The incumbency period.
That the service of the petitioner.
My lord.
1 minute. If you substantially complied, then what?
Not complied, my lord. For better represents this honorable court, my lord, I am to submit here with my lord. After filing a contempt application, my lord, they filed an objection, my lord. And the objection, I have filed an petition, my lord, an objection to show cause. They have filed a show cause affidavit. Thereafter, I filed an objection to show cause affidavit. And after this objection show cause affidavit, they have filed a rejoinder, my lord. Rejoinder. And in categorically, I have stated that has not been complied, my lord. Kindly have a glance to my objection,
This
my
is the
lord.
last occasion. This one I have filed the rejoinder. The Lordship have a glance to para 7 onward.
Rejoinder, huh?
Yes.
Objection to show cause. Where is rejoinder? Rejoinder is not there. Rejoinder is not there here. Here, you have filed rejoinder. Okay.
Lordship, para 7 at page 3.
Yes.
The service of the petitioner has already been regularized in a different phase, and financial benefit has also been extended to the petitioner mostly by the appellant authorities. The salary, area, provisional pensions, area, unutilized leave, etc. in favor of the petitioner amounting to rupees 31,07,997 as per the letter dated annexed.
What else is left?
Well, everything has been left. I have all the documents filed. All the documents were there. Their documents I have filed.
You tell me what are the benefits given to you?
What is the order, my lord? Yes, my lord, specific allegation is that, my lord, I have mentioned in my objection, my lord. I am reading.
These are very
Yes,
clear.
my lord.
Written all this.
That the entire service period of the petitioner was not regularized and his consequential service benefits was not sanctioned and his service week was not made up in order
No,
to
sir,
enable
if you make like that claim, you will
I
not
am
get
not
anything.
claiming, my lord. Order was like that, my lord. Order of the honorable tribunal was to regularize my service and
say
to-
that they have regularized you.
not regularized. Where they have stated, my lord. I have filed the objection, my lord. In categorical, they have not
Annexure
mentioned.
G, go to
Yes.
Annexure G.
My lord, I am reading they reply, my lord. In they replied what they have stated lastly, they have replied that the deponent, yes, my lord, that the respondent has also apologized to honorable court, submit a further extension of time to provide for compliance of this honorable court order. My lord, they are always confusing to this honorable High Court, my lord.
It is not
And
a
so I have filed
documents
an
are also
objection.
attached to the documents.
Their documents I
Show
have
me
filed.
the document whereby he has been regularized.
So that is first one is C/3, lordship. C/3 at page. At page, lordship.
Where in rejoinder C/3.
Yes.
G/2.
Yes.
Huh?
Yes.
What? G/2 or C/2? What is which document you are talking about?
My lord, all their documents I have filed my objection, my lord.
1 minute, let us check. See,
My lord.
so, in a contempt jurisdiction under section 12 of contempt jurisdiction, we have to see substantive compliance has been made on.
Yes.
If any further grievances
Well,
are there,
three
you
contempts were
can
there, my lord.
agitate it in a appropriate proceeding. Substantive compliance is there or not? That
My lord, I am running this honorable court, my lord, since 2005, my lord. And
yes, sir, regularization, show me document.
Yes.
Where have you regularized? There are two issues. One is regularization
and pension.
Second is the financial benefit. Whatever financial benefit. You say 31 lakhs something you have paid. He may not be satisfied, you may be satisfied, that is a different story.
But
whether you have regularized or not.
And
show me the document whereby you have regularized. Simple. In the calculation, there may be here and there.
Minor.
But show me the regularization. If you have regularized, finish. Because in part 7, you say that you have regularized.
C/3, lordship. Earlier complaints.
Where C/3?
Complaints occurs.
There is no C/3. Do you have that document or you want that document to place on record? Just see, tell me. The main important thing is regularization. If you have regularized, show me the document. Otherwise, I'll frame contempt notice. Simple.
My lord, this objection has been filed by another fellow, my lord.
That is the whole problem. Objection in a contempt jurisdiction, rejoinder, this, that. Why pleading so much of pleading?
No, I am not about saying pleading.
That is the reason
I
he
am only
confused.
one technical point, my lord. As per the order of this honorable court, the notice has been gone to the contempt. Another fellow has filed this affidavit, my lord.
You are interested in your regularization, you are interested in your...
My lord, regularization.
Don't
But so far as the contempt of court is concerned, my lord, if this honorable High
you
Court
want to regularization or you want to send him to
no
jail?
more regularization.
Then I'll send him to jail. You be happy. Why unnecessary? You are interested in regularization. Let us see regularization is done or not. Shall I put it on Monday or Tuesday so that you can set it out? You only tell me when have you regularized? Show me the document, regularization. First.
Yes.
Second is, in so far as the financial benefits are concerned, you have to compute that and give it.
Yes.
You have computed 31 lakhs or something.
Yes.
He may not be agreeing with that figure. And I'll ask what are the figure. We'll reconcile that.
Yes.
These are two things. Why unnecessary so many document volume after volume?
You are suspended for a 12 years or 13 years.
I don't know anything. In a
cases are
contempt,
there.
in the contempt jurisdiction, I need not go into all these things.
Yes, yes.
Two things I need. One is regularization, another is financial benefit. You show me, I'll drop it.
Everything is completed. It has not been up to date till date because of his different.
I don't know anything. These are not the issues to be gone into in a contempt jurisdiction.
Yes.
You may have 1,000 problems. If there is an order, you should have challenged that. The High Court says that you should challenge the Higher Court, get a stay. You didn't get the stay. Today you are facing difficulty. You face the difficulty. That is your problem.
Yes.
The High Court is very clearly indicating either you go to High Court, Superior Court, get a stay or comply.
Yes.
Today you can't say that I have this problem or that
No,
problem.
that is not, I am not saying because of the up to our service book will not update. How RSCP and SCP will be correct?
I don't know anything.
Yes. Yeah.
I have to. Why, when all these things are not relevant for me? Relevant for me is whether there was a direction for regularization. Regularize. Have you done or not? Show me the paper. If you regularize. If and financial benefit.
I have filed this I/2 of this objection, page 21, Lordship.
Show me the regularization letter.
That will I, Lordship, just have a glance.
21.
Yes, page 21, annexer I/2, J/2.
21. How many annexures you people are filing?
J/2.
I see. J/2. 22. Yes.
We are asking
number of correspondence
yes,
have
these
been
are
made by
correspondence, but
different.
he is not turned up. Staying in a house that you do all these things without my help.
Regularization of service and submission of the pension paper. That regularization has not been done.
But this, he is not coming up for the documents to provide us.
I have already mentioned in the objection, my lord, those are not required. All the documents I have filed. My lord, kind of class to in objection. Every documents has been with them, my lord. Where I was served, I have served in different station. All the documents are with them. Even if that I have filed all those documents. Now they are saying that you come and you come. This is the letter, my lord, only to the direction is to regularize my service from different station. What necessary I have to go there in
Service
office
book is not
only
there
to
with you.
get money from me, my lord.
Service book is not there with you. What are these letters? What are you asking?
Asking all those documents.
Which
what is
document?
with him also. Suppose he has given
These
the charge
documents
to
are
some other
supposed to be
person.
there with you.
Yes. See, if you will not give the charge to another person who are there, how that will be regularized? Suppose you will make the payment. If 31 lakh, that is what we have calculated. If
How have you calculated 31?
That only as per this first scale of pay we have calculated. Accordingly, we have calculated this one. But suppose he has to pay something which he has not discharged the charge to other person.
Where are the
that recovery cannot be made after the.
No, you have given a list of letters you have issued to him.
Yes.
Show me the color of those letters. Let us see what are you asking.
Next page, Lordship. Continuous page is there, Lordship. I think you are asking him.
This is dated page 23, dated with reference to above. You have requested to submit your pension papers to this office immediately. So as to you don't have pension paper, his pension papers.
The service will not provisional pension is getting. But service book up to how it will not update.
2013 ରୁ ମୁଁ ରିଟାୟାର୍ଡ କଲିଣି ମତେ କହୁଛନ୍ତି ପ୍ରୋଭିଜନାଲ ପେନସନ ଯେତେବେଳେ କଣ୍ଟେମ୍ପ୍ଟ ହେଲା ମୋର ସ୍ତ୍ରୀ ବି ଚାଲିଗଲା ତାଙ୍କ ପାଇଁ ଆଜ୍ଞା ମୁଁ ଦେଲେନି ବୋଲି ମୋ ହସ୍ପିଟାଲ ରେ ପଡିଥିଲା କ୍ୟାନ୍ସର ରେ ଚାଲିଗଲା ଆଜ୍ଞା ତାଙ୍କ ଡକ୍ୟୁମେଣ୍ଟ ନିଜ ଡକ୍ୟୁମେଣ୍ଟ ଗୁଡା ମୁଁ ସବୁ ଦେଇଛି whatever is
where is the original GIC passbook?
all are with them, my lord. Everything is there, my lord.
You have photocopy?
My lord, I am the petitioner, my lord.
Do you have the photocopy of these documents? They are asking.
Yes, I have already submitted, my lord. Only they have to regularize my service. If that service is regularized, then all the problems will be solved, my lord. And all the letters are objection, my lord. Kindly have
Don't make a ego
objection
issue.
to show cause, my lord.
Don't make an ego issue. You tell me one thing. They are asking some papers from
Yes,
you.
I have already submitted.
Do you have those papers or have you given?
No,
Show me
everything.
Show me that you have given. this document to?
My lord, now they have filed this document. Earlier they have filed an objection, my lord. Objection, I have complied detailed report along with their letters. I have not a single letter, my lord. All the letters are there, my lord. Their letters, their office letters. I kindly have a glance to my letters, my
Who is
lord.
the contemner?
My lord, here's my lord.
Who is the contemner?
Contemner is my lord. G. Mathi Bhatanam, my lord.
Lordship, keep to
Only one.
I will frame notice of contempt.
Just keep to next week. I will get all these documents.
See, the orders are very apparent. You are making him to run here and there, give this paper, give that paper. What is this going on? I'll frame notice, let him come and explain.
Submit that.
Okay, 1 week, let him, 1 week, he's asking 1 week. And don't ask these papers.
Obviously, no doubt about it. I am always.
You want to avoid the direction.
Yes.
If you had no paper, you should have told the court.
Yes.
Today you are asking this paper, that paper, 1,000 letter you have issued to him. He has as a poor guy, his wife died and all. What is this going on?
Well, since 2005,
I'll
I am
frame
running
notice.
thereafter, my lord.
I'll frame notice on Tuesday.
My lord, my lord.
If you don't show me the regularization letter, I am going to frame the notice.
Yes, Lordship,
No escape.
Keep it to come next week, Friday.
Friday night, Thursday.
Yes,
Okay, Thursday.
Yes,
Take it from me that I am
Yes.
framing notice on that day.
yes.
My lord, only regularization letter they may be complied. my
That's
lord.
what I am giving 1 more week and simply tell that I will frame a notice and some
Yes, yes.
problem will be there.
Yes.
You can't drag on like this. And you have given a list of letters, 100 letters you have written to him.
I'm not for that.
Instead of complying, you are going to him. What is this? You simply tell whoever it is, principal secretary. Who is the principal secretary of this department, urban development?
G. Mathi.
Now, today, this was filed somewhere in 2023.
My lord, G. Mathi, my lord.
No, who is today? He might have been transferred also.
Name will be changed.
If I frame notice, then he'll come and say that I have been transferred. Huh?
Opposite party number 2.
And you get information regarding the fact who is the principal secretary for housing and urban development
My lord, my lord.
on Thursday.
My lord.
I'll have to frame notice on that contemner, not Mathi.
My lord,
Mathi
only
Pathana.
one suggestion, my lord. In my objection, I have filed all the documents of the office, my lord. Their officers' documents, my lord. I have not regularized. All the documents are there. My salary was not paid. Charge report was filed. Everything is filed. They have not replied those documents, my lord.
All the documents must be there. That you don't have. Anyway,
I have also assisted them, and so I filed this objection. my lord.
Thursday. Yes.
47.
Yes, sir.
My lords, on behalf of Mr. Debashis Panda, I pray for this matter to be taken up some other day, my lord.
Why? What is this matter?
My lords, I have no such instructions. I'm not even associated to his office. I'm not well versed with the brief.
Sorry?
My lords, I'm not well versed with the brief. My lords, I pray.
I'm not able to hear you.
My lords, I'm not well versed with the brief. My lord, I pray let the matter be taken up tomorrow.
On behalf of Mr. Debashis Panda, Mr. So-and-so, taking Mr. So-and-so seeks an adjournment. By way of last and final opportunity, the matter is adjourned to next week.
Tuesday.
27. And in the meantime, the petitioner as well as the respondents are directed to file written submission.
I have already filed.
If not filed, may file the written submission, not exceeding 10 pages. Leave the matter for final disposal. Yes.
Much obliged.
48.
This case, my lords, lordship permits, my lord, of the year 2003, my lords. The second case is item number 50, my lords, of 2005. these two matters, my lords, my lord, despite my best effort, I couldn't have listed, but I'm grateful to the registry for listing these old matters today. My my prayer is, my lord, this matter.
I have instructed that all the old matter will be
Deep low place, my lord, because there some amount of accountability is there, my lord. Why not taking steps? Why not disposing matters?
all old matters. If you have any matters,
no,
I'll
give
the
that
numbers.
list.
I have to wait.
No, I have got the serial the list. I will give it to you, my lords.
Give it to.
But today these two matters will be
everything will
dis-
be.
That will be convenient.
and my lords, sir.
And they.
No, I have got I have got the list. No, move the Jura pending list.
Check for them, okay?
Yes, yes. And so far,
Yes,
but the today's quota is item number 40 is and 50, my lord. Of 2003 and 2005, both the matters may dispose of, my lord, in this or that, my lords. Because in 2003, my lords, this is a case, my lords, where two accused persons, the one accused person's the wife is running that particular business of bond mobiles, that lubricant business, my lord. And the husband, in the guise of this power patent holders, my lords, may not say running the business, my lord. And their case is that they are procuring burnt mobile oil from the local garages and preparing industrial oil. But they could not produce any kind of documents, any document.
No, what is the offense?
The offense is section 7(9) of the Essential Commodity Acts.
Essential commodity. What is conviction? What sentence?
No, this is an application for allowing an application for discharge application rejected. They have come up.
2003 discharge. What is the stage of trial?
No, in fact, they got the interim orders. They got the interim order on 7/11/2003, my lords, and thereafter it was dismissed on 2/12/2023, and it was recalled.
This court has passed interim order.
Yes, my lords.
Where is that?
On 7/11/2003.
Don't think there is any order. 7/11/2003.
2003, my lords.
And it is pending, and you people have not moved application. What is it?
And thereafter it was dismissed on 2/12/2003, my lords. It was dismissed, and that dismissal order was recalled on 2/7/2004.
Where is the interim order?
Interim order is, my lords, is at page.
In the record, there is nothing. Is there? Order number 6. Third interim.
7/11/2003.
Interim stay of the further proceeding. This is the case number 1.
The next order is 2/12/2003. It was dismissed. They got the interim order without serving copy to the state.
Petitioner for the petitioner PPS cancellation to 2024. 2024. The request of land counsel for the petitioner on 30th April 2024, on the request of land counsel for the petitioner, the matter was adjourned to 17th May 2024. When the matter is called up today, none appears for the petitioner. Mr.
Sangram Das, standing counsel.
Das, land counsel for the respondent, submits that there is an interim order is operating since
7/11/2023. 2003.
2003. As a result of which the trial has been stalled. In the present petition, petitioners have challenged the framing of charges.
No, an order rejecting the discharge application.
Order rejecting the
discharge application.
Discharge application. In view of the fact that due to the interim order, the trial is stalled for about 20.
One decades, lots.
More than 2 decades.
2003.
About 13 years. About 13 years. Leaves the matter on Monday. I'll vacate the stay and. Okay, Monday रखो इसको. Yes.
49.
All these matters are.
49 minutes, Mr. On behalf of Mr. Chinchari.
Yes.
Please touch.
What is happening here?
49 minutes.
Was there any stay here? What is this matter?
48 gonna.
49. In the meantime, Mr. Gokulan Mahathur expired.
What is this matter is about? This matter is regarding?
Well, let's now in Discover, this is a Mr. D.K. Mahapatra appears. He was the senior standing counsel of Vigilance. The file is not with me. I'll go through your lordship brief minutes. Let it come on Monday also.
Non-APS for the petitioner. This is the matter on Monday. I don't think anything is survived.
I'll verify lordship records. I'll come back to your lordship on Monday.
The old matters are listed. Many of these matters will be like this.
No, I will be.
And many matter, what happens is stay is operating, everything is solved.
Has already been in.
Nobody is bothered.
And maybe because of that orders passed in that
So that's the
AC and suffrage
That's the
judgments.
reason I've instructed all the old matters to be listed.
Yes,
At least let us see what is happening. Yes, next.
50.
So, well, item 49 minutes coming on Monday.
Monday. You people have to cooperate, otherwise nothing.
We stand boldly behind this particular purpose.
Item 50.
Well, it's 50 minutes. This is our case of 2005 minutes. Well, this is also a case minutes. Nobody appears. Well, it come Monday minutes.
This matter is pending since 2005. In many occasions when the matter was called up, none appeared for the petitioner. Today also, there is no appearance on behalf of the petitioner. In the interest of justice, leave the matter next week. Nobody appears, I'll discuss.
No, Monday minutes.
Next week, Monday, Tuesday, Monday. Only
51.
On behalf of Mr. Bose, my lord, keep it Monday, my lord. I'm taking instruction again.
Is there any?
Survive. No, my lord, I think, my lord, it's a DA case, my lord. Charge already framed. Lordship, turn to page 91, my lords. My lords, the trial commenced, my lord, up to the framing of charge on 24/4/2006, my lords.
Then what remains? Charge frame long way. And you are challenging what?
In a disproportionate case, my lords, the challenge in order framing charge, my lords.
2006 charge has been framed.
Let them take all the liberty, my lords, to raise all the cases.
Just keep it one day, we're given time to serve.
Monday, you seek instruction, there is nothing.
Oh, my lord, my lord.
And rightly he says, reserve all the rights and go and.
My lord, my lord, my lord.
Okay. Monday, huh?
My lord.
Monday. Okay. Write down. This is a matter pending since 2006. The petitioner has challenged the framing of charges.
Yes.
Petitioner has challenged the order dated 3/3/2006 passed by the Special Judge Vigilance, Barampur, in GR case number 19 of 1996, whereby charges against
frame in a DA case.
Charges against the petitioner in a DA case has been framed. Mr. Das and counsel for the petitioner respondent submits that much water has already been flown by now, and the trial has proceeded. The counsel for the petitioner seeks
since 24/4/2006.
Trial has already been proceeded as the charge was framed on 24.
Charge was framed on 3/3/2006. 3/3/2006.
The counsel for the petitioner seeks 1 week adjournment seeks adjournment for seeking instruction regarding the matter. Leave the matter on Monday.
52.
52, my lord, here in this case, petitioner has already taken consent from us. And Mr. Arun Mishra entered appearance on 17/6/2013. So our name may be deleted from the cause list.
Yesterday, my lord, the case has been heard, informed Mr. Smruti Ranjan Mahapatra Junior. I have informed, he is come.
So what do you want now?
My lord, petitioner has taken consent from us. Thereafter, my lord, one Arun Mishra has entered appearance. Our name may be deleted. Mr. Smruti Ranjan Mahapatra and associate.
Then counsel on behalf of Smruti Ranjan Mr. submits that the client has taken consent from him, so therefore his name may be dropped from the cause list. Mr.
Arun Kumar Mishra has entered appearance
Arun Kumar
on
Mishra appears to have entered appearance, but none appears on behalf of the petitioner today. Hence, in the interest of justice, leave the matter next week.
Interim order. Interim order.
You are for petitioner.
I am for opposite part number 1.
Why are you interested in interim order?
Why interesting matter? Your lordship has previously directed to deposit 1 lakh. That is the.
There is no interim order. You tell me.
9/7/2013.
13, but last order there is nothing. It is not extended.
Last order is 9/7/2013.
Now 19/6/2024. It is not extended.
Yes.
Then
9/7/2013 the last order was.
no, last order is 19/6/2024.
Yes, previous order was that to deposit 1 lakh, they get stay order.
Who got? They got stay order.
Yeah, petitioner.
Petitioner. Then why? What do you want?
9/7/2013.
Already deposited 1 lakh rupees.
Yes.
Okay. This is 138 case.
Yes, sir. That was hard, my lord, yesterday.
You are for informant.
I am for complaint.
You got 1 lakh rupees.
No, that was deposited in the lower court.
You have not got it.
Not. Your lordship may direct.
You have moved an application. Have you moved an application before this court?
I don't have information whether I have filed it.
You move an application before the court below where it is listed and get it released.
I'll take instruction. Monday,
What instruction? I am giving a direction. Go and do it. Monday, you tell me that 1 lakh rupees is released.
Monday.
Right down. You are for opposite party number?
1.
Pursuant to the order dated 9/7/2023, the present petitioner.
2013, man.
Pursuant to the order dated 19/6/2013, passed in Miss Case number 262 of 2013. The petitioner had already deposited 1 lakh rupees in the trial court, trial court. If there is a direction that it will be released to you.
Yes.
There is a direction already.
Yes.
It might have been released by now.
I'll take instruction.
That's right. Which weapon? Release the matter. Yes.
Monday. Okay.
53.
May I please, your lordship?
Yes, sir.
My lord, there are 3 appellants before your lordship.
Yes.
They have been convicted under section 490A by 34 by the SDGM under and directed to undergo RI for 1 year.
Directed to
Undergo RI for 1 year.
1 year.
1 year. 3 months for section 4 of DP Act and 3 months for section 6A of DP Act.
Okay.
They preferred appeal and it was partially allowed. 6 was set aside and the others remain as it is, your lordship. Against that order, we have filed this revision, your lordship. But I have 3 points before your lordship to argue.
Mr. Gada, are you ready?
Well, first point is, your lordship, PWT is the victim, wife. PW1 is the father, PW6 is the mother.
Okay.
And my first submission is that they have developed this case during the trial.
Yes.
Because where their statements were confronted to the IO, the IO stated that they have never stated these facts about the demand of dowry to me in the initial stage, your lordship. This is the first one. Second point, Your Lordship, matter has been compromised between parties, Your Lordship. That was reflected in the judgment also, Lordship. That the matter has been compromised between parties, but that was not taken in care of by the learned appellate court, Your Lordship. Your Lordship, kindly see.
Trial court order.
Trial court order, appellate court order, para 7.
Appellate court order.
Again.
Para 7.
7. Additional session order, para 7. Relying upon the certified copies of order dated 17/4/2013 passed by in RFA number etiki, it is submitted that learned advocate on behalf of the appellant that in the meantime matter has been compromised between the parties, for which this court should be give due witness to the above facts during the analysis of evidence. Offense under section 498A and section 4 of DP Act are not compoundable in nature. Therefore, this court is not in a position to entertain the compromise if any arise between the parties. I have already mentioned the London SDGM Pulmani. Matter compromise भी ହେଇଥିଲା party ରେ. In between 20 years of past, Your Lordship. Lordship, kindly see their age. Father-in-law is now ସେତେବେଳେ ଥିଲା 74, ଏବେ 84 ପାଖାପାଖି ହେଇଯିବଣି, ବଞ୍ଚିଛନ୍ତି କି ନାହିଁ ଆମେ ଜାଣିନୁ. ଆଉ mother-in-law 69 ସେତେବେଳେ ଥିଲା, ଅବିକା 79 ପାଖାପାଖି.
30 years. Father-in-law
69 at the
Satyanarayana Padi, who is Satyanarayana Padi?
Satyanarayana Padi is husband.
That time 42. 42 ଥିଲା. ବର୍ତ୍ତମାନ କେତେ ହେଇଛି?
52. 10 ବର୍ଷ.
And
ଏମାନେ
Padi 72.
74 ସେତେବେଳେ ଥିଲା, ଅବିକା 84 ହେଇଯିବଣି. ଆଉ ଇଏ 69 ଥିଲେ, 79 ହେଇଯିବଣି ବର୍ତ୍ତମାନ.
What are the evidence?
Evidence, Lordship, kindly for evidence के लिए dowry ମାଗୁଥିଲେ, ଲକ୍ଷେ ଟଙ୍କା ମାଗିଲେ. ତାପରେ 2004 ରେ ମ୍ୟାରେଜ ହେଇଥିଲା. ତାପରେ 2000
Who are the witnesses?
witness main ହଉଛି 1, 2 and 6.
1, 2. Who is one?
One is father.
Father of the. And 2.
2 is the
what
wife.
happened to their marriage?
Marriage, my information is that divorce allowed ହେଇଯାଇଛି ତାଙ୍କ ପାଖରେ. ତାର ଆଉ କିଛି ତ ଦଉନାହାନ୍ତି, ଆମର ଚିଠି ପିଠି ଲେଖିଲେ ବି ଆସୁନାହାନ୍ତି. ପରେ ବଞ୍ଚିଛନ୍ତି କି ବି ନାହିଁ father-in-law, mother-in-law, doubt.
And just let us see. Father-in-law, mother-in-law, he live. Satyanarayana Padi against the ଅଛି ଦେଖନ୍ତୁ.
Paragraph 3, my lord.
3 of appellate court.
Appellate court last paragraph. Page 3, my lord. Internal page 3, continue page 7. Now it is the duty of the court to scan the evidence to ascertain as to whether Kalandas was subject to cruelty within the meaning of the section 498A IPC. The victim, her parents, younger brother, and a father in a categorical term have stated that at the time of marriage there was a demand of cash rupees 1 lakh besides other household articles, but the informant could not pay the cash as he could not draw the amount. Petitioner 1 has further stated that on 13/4/2004 he paid a sum of 80,000 to the father of the Satyanarayana after withdrawing the same from the GPF, and the same was deposited in the name of Satyanarayana and Kalyani by way of Kisan Vikas Patra. The victim has further stated that she was subject to ill treatment as sufficient amount of gold and further cash rupees 20,000 was not duly given. With regards to the all ill treatment, the victim Petitioner 2 has categorically stated that immediately after the marriage, the appellants scolded and assaulted her at a different point of time. Further, Petitioner 12 proved that seizure list of GPF accountants roll of the teachers of the Khajuripada block, and there was even absolutely little cross-examination on the discredit the credibility of the said witness. But 3 things, but 3 things there were down 3 times. Prior to the marriage, they demanded dowry, accordingly 80,000 given. And rest 20,000 had not been given. For that, they have been treated and scolded and assaulted. That is their allegation.
Then the money withdrawn from GPF was again deposited in the name Satyanarayana.
No, but Satyanarayana and
Kisan Vikas Patra.
ତାଙ୍କ ଦି ଜଣ ନାଁରେ ମାନେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଜଣ ନାଁରେ ଡିପୋଜିଟ୍ ହେଇଥିଲା, ତାଙ୍କ ଆଙ୍କ ନାଁରେ ଖାଲି ନୁହଁ, ଦି ଜଣ ନାଁରେ ଡିପୋଜିଟ୍
and
ହେଇଥିଲା.
rest 20,000 that for that reason they have ill treated and scolded assaulted. That is the allegation.
ସେଗୁଡ଼ା ଆପଣ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଦେଖନ୍ତୁ ଆଇଓର କ୍ରସ୍ ଏକ୍ସାମିନେସନ. It is a fact that PW1 has not stated before me that there was a demand of 1 lakh prior to the marriage, and that he has not stated that the presence of
What is the Satyanarayan is doing
Satyanarayan,
for living? He's a government employee. You will have to tell us. What I am thinking at large is mother-in-law, father-in-law acquitted. I'll acquit them.
And extended
And insofar as husband is concerned, I'll maintain the conviction.
And extended PO.
PO. Finish. You are happy, prosecution is also happy. That's the best way of doing it. If he's not working, government, if you want to save his job, then we will go further.
सोमवार को रखता हूँ चेष्टा करियो तंगो ये करिया पे खाली पचार देवी गवर्नमेंट
This is what I am thinking.
Yes, your lordship.
Mother-in-law, father-in-law definitely acquitted.
My lord.
No problem about it.
My lord.
And in so far as the husband is concerned, reduce the maintain the conviction, give the benefit of PO.
My lord, I have a judgment to that effect. That due to the compromise ହେଇଥିଲା conviction ପରେ ବି ହେଇପାରିବ lordship kindly see 2001 supplemented to LR 498 section 4 of DP Act conviction under judgment confirmed by the appeal revision mutual divorce between the parties under section 13B of the Hindu Marriage Act informant wife undertook to withdraw all the proceedings initiated by her against the petitioner. No appropriate steps was taken by her. Petitioner acquitted of the charge of this case.
Done here, my lord, if the
It
wife
is compromise
is affidavit here.
But she has to come forward. No? Where is her evidence?
Uh,
Where is
set-
her evidence? Where show me any paper whereby the victim has stated before court that I don't want to push.
No, that is not there, my lord.
But sir, RFA ରେ ଲେଖିଛନ୍ତି
Analysis
compromise
check.
ହେଇଛି ବୋଲି.
ଲେଖିଛନ୍ତି କିନ୍ତୁ କାହିଁ? Where are the show me some?
Paper ମୋ ପାଖରେ ତ ନାହିଁ ସେଟା.
Then the judgment benefit you can take. Why to get into? You tell me. I'll
Yes, sir,
I'll
yes, sir.
acquit 2 and 3, and insofar as 1 is concerned, extend the benefit of probation of interception. Finish it up Monday.
Monday, your lordship.
And if he's working, if he's a government employee and all, his service will be affected. Then we will think how to take him out by giving an acquittal,
Yes,
so that his service will be not affected.
Yes.
You just work on that.
Aye.
Monday, yeah. Right. Let it be Tuesday. Weekly list.
Yes, sir.
Yes.
What if it? The weekly list.
Any other matter?
Item 57, my lords.
How
Item
many matters are?
My lords,
20 matters. Then I'll have to come.
may make a submission. My lord. Item 57. On behalf of Mr. Chinchani, Pratap Chinchani, my lords, he requested to make a mention, not today, my lords, next week.
Tomorrow.
Next week,
Let
my
it
lords.
be there on the board.
My lord, same prayer in 58. This is a vigilance matter. My lord, I have already prepared the affidavits, my lord. It will be filed on Monday, my lords.
50?
58, next case.
What I will do is I'll put it on the weekly list.
Huh,
I'll accommodate, don't worry.
57, 58.
57 and 58 weekly list there. So that rollover at least matter will be.
My lord, item
That's our
54.
item
number.
One after another. Yes.
73 for hearing. That's the vigilance case.
Again, weekly list.
Why not? Many matters have been fixed in different dates. As it is for final disposal, this is the appeal against the final confiscation order.
Connected matters.
Yes, let it be on 25th of July, so that I will intimate the other party that because it is a
25th July.
it is a voluminous brief. Just
Yes,
now,
25th July.
Yes.
Let's say, my lord, item 56 and 67, I prefer adjournment.
56?
Man, 67.
Why adjournment? You are asking adjournment in all the matters. Why?
Let's need some time.
Huh? Weekly list.
My lord, item 54.
I will not adjourn because old matters, it will be there in the weekly list. One after another, we will take it. So that at least you will also be alert.
My lord, item 54, on behalf of Mr.
56
Diraja Prasanna Das, Mr. Das is not well, so kindly be taken up the matter next week.
67. Prasanna Das matter.
55 plus.
I have 54.
54.
55 plus.
Pardon,
Item
my lord,
55 plus. I am for the respondents. I am for the opposite party. copy not served the first hour Lordship, I
What do you want?
intimate the petitioner the next week maybe.
That will be there in the weekly list. Weekly list. Let it be.
Pardon, my lord, item 58.
1 minute. 55 weekly list.
55.
55. Yes, yes, sir.
Item 58, my lord.
It's coming on Monday. 58 coming on Monday.
My lord, my lord. My lord.
Withdraw 59 withdraw. Yes, 59 withdraw. 59 withdraw. 58 weekly list. Anything else? No. There are a couple of matters to do it after. Thank you.
Internal page 8, annexure 1 million. Increment for 1 year with fine rupees 1,000. 47 of Odisha. There Millard in appeal partially modified and Millard 6 months and Millard fine Millard. That is Millard.
I'll give section 426.
Yes.
That's what it is. Section 4, judgment period. Yes. One.
There also a person where it's excited, my lord. 1 year conviction.
Clear?
My lord. 1 year. Right for 1 year.
अभी क्या कर दो?
Asit ko dyan na. So, meron din mo 1% discovery. Meron discovery. Give it up.
Move forward. You assist us. Huh? I'll put it tomorrow. Take this file and read it. Tomorrow. Yeah. Tomorrow. Tomorrow. And came over and passed. And you tell me for the next query.
So they have given the name, they have not copied my letter. Whenever the matter is listed, they have.
And you tell me how the fees is given?
But they have engaged by the legal and fees less my lord. But whatever you got sick my lord ask, they will give.
Who will give?
By the legal and legal. Second,
will you please tell me
some cases my lord, other courts my lord, they are including 10,000, 15,000.
But you just tell me so that
Legal services authority. Legal services. They may explain that.
But since they are the amicus school, my lord. But otherwise, my lord, if the legal those who are appearing.
Yes, ma'am. Yes.
If they appear legal and my lord, then yes.
They have a particular structure.
Part of order.
And if they appear to the legal aid authority, they have a particular fee structure. They cannot exceed that structure.
So for amicus,
If your lordships are appointing directly from the bar, then the fee structure will be according to your lordship's desire.
PS for the petitioner. This is a revision petition filed in year 2011. Therefore, I feel it appropriate to appoint
Three.
Directly to supply the people course of the day, please come out for the take our paperwork and do it. And please just see if you can get some order or the format of order or a direct BLA to pay. If you can.
Some orders were.
Get some order, one order or two, accordingly will follow. I'll call the secretary and all, it takes its own time. Please, yes.
I don't know, substituting in the paper is short adjournment. Written letter.
In documentary, you want to do.
I have sent a letter to the party, but he has not.
3 years, madam.
To obtain the status of the petitioner. What was the age at the time of conviction? Just see. That is very important. What was the age in the year 2003?
36. 36.
No, 2003, na? 2003.
Yeah, appeal file 36 years.
Appeal file. Where the status, huh? Yes. Next week? Yes. Next week?
The life has.
Get ready tomorrow, you'll be here, huh? Yes.
The permission 323 and 354. 6 months and 3 months, respectively.
Here for the petitioner.
I think some cases is also can some cases is also may since non appearance for the petitioner, there is the judgment at
what I do is
you also can direct disposal.
No, where there is none appear, what I'll do is I'll record that and let them next day. Then I'll appoint amicus curiae.
Even if in the absence of amicus curiae, you also can directly
Yes,
on merit.
but the idea is to encourage the youngster. Some youngster can at least read it.
Yes.
That's the idea.
Some persons given their name, but they can.
That's the whole. You tell them, let them come here. Those youngsters, let them come so that they can take the file.
Already in advance.
You at least you'll be there in the court so that we can. I'm continuing this matter to Monday. You take the number, be there. Monday I'm appointing you as a amicus curiae. You get ready for Tuesday and Wednesday. Additionally, non-APS for the petitioner, again to also. For a pencil today, I can come on Monday. I will appoint him. With you, he will be appointed on Monday. And do one thing. Whatever paperwork are there, get a photocopy and keep. Monday. Yes. Straight away it will be photocopy from our paperwork. See the photocopy and answer. Otherwise, you can't.
Yes, if you go on the ending.
Yes, sir.
People want to pass over. None friend is coming. We study he was there.
Pass over. Oh, yes.
Regularly coming to court, they manage for us.
Non-APS for the particular urgent service. In interest of justice, these matter next week in the game. The BS are the point. Yes, sir. I don't know. Next week, I don't know. I don't know to go on to file. Let it be there in the weekly. Okay, you get ready. What is the offense?
You are available.
332 conviction.
332, 1.5 years. The
Conviction I maintain and sentence I
1.5 years.
It's all right. He will be benefit of provision of offense.
So, my lord, what has happened in this case? On the basis of compromise, they filed application to the appellate court.
No, my lord, what happened in this case, my lord? Appellate court, my lord, both the accused persons, appellants, they released after due admonition by the learned trial court as per section 3 of the provision. How can I be the you have to check what 3 that is what? वाला पर populate certificate दिख रहा है the result is upheld by the allowed contest the conviction both the appellants on up to 341 332 34 IPC hereby confirm. However, the offense on 341 of the IPC having already been compounded and as per the discussion made above, both the accused persons appellant be released
after due admonition by the trial court as per section 3 of provision of offense act and sentence
data disposal.
Simple disposal. Simple disposal. With the head on it. Order. Record for the disposal.
It is the point is that you are dynamic, you are percent you person of officer of something.
Its own death without
sometimes you have the professional officers are proactive manner where all the giving the bond or keeping peace and
shall I say that they furnish a bond? That's a better idea.
After release, they not.
And then that domicile soul will be hanging on that. Once they go and file a bond, finish. Personal bond.
And he's
I will say that
that is the act.
I'll do that. Yes. Next. 60? 68.
67 level?
68. 68. So the new things are called. Now you call. Let us see who is there. 68 fine. What is the offense here? The 307. Non-APS for the petitioner in the interest of justice. Next time, come again.
Shastri.
ये कौन है पिछला 376 something 4 What is the juvenile? 376 juvenile pay 1,000 and 1 year, 1.5 years in the special home. Non-APS for the petitioner, that's by second call. In the interest of justice, urgent to be the investigation.
70. Well, 1 year conviction for the offense.
1 minute, 1 minute. 1 minute. When the what about the petitioner? So, the matter was last the matter when the matter was lastly taken up by the court for hearing on 21/1/2015, none appeared for the petitioner. Accordingly, this was dismissed for non-prosecution. Non-prosecution. Again, restore what?
One 15
Dismissal default. Orders are not placed. Whether it is restored. Accordingly, the miscase is dismissed for non-appeal. Non-appeal, huh?
What 611? Dismissed number 611 by 13 dismissed. Miscase is dismissed.
Main matter is there. Non-appeal, लिखित ना on 21/1/2015 in the interest of justice urgent for next week.
1 year conviction for the offense 324/34 of IPC.
70.
Mile.
1 year conviction.
Mile.
Offense
324 of.
How many of you are there? 3.
3 persons.
Yes. Tell me.
The allegation is that while the informant present at the place, at that time all the petitioners were came and assaulted them. Especially the appellant number 1, Nabagan calls a physical assault blow by an axe. And then there are many eyewitnesses who belongs to the family members of the informant, and no other witnesses are there. Apart from that, my lord, as per the PW8 with the doctor, he specified that there are 3 injuries. One is a lacerated injury, and pain and swelling, and abortion. Apart from that, there is no evidence.
Though they have been acquitted, my lord, under 307/34 IPC, but they have held guilty under section 324, 223, 34 of IPC, my lord. Implement conviction to undergo implement for 1 year and pay fine 1,000, my lord. And default to
undergone. Sometime you have undergone or not?
No.
307, they must be undergone sometime during the investigation stage. That has been taken into consideration.
Have you undergone?
I have no instruction on that.
Verify from the LCR.
See the LCR.
Well,
See the LCR. And you have not argued anything. There is no evidence. That is the argument. Who are the eyewitnesses?
Eyewitnesses are the family members, my lord.
A family member, family member doesn't mean that they will be discarded. Family member can also be eyewitness.
My lord.
So then see the version. Are you saying that they are interested in witness?
Yes,
or
interested.
falsely implicated? There was enmity or something.
They
What
are
is your defense?
they are the interested witnesses, my lord. One
Why they are interested? Because they are family members.
family members. Belongs
Merely
to
because
family.
they are family member
Belongs
that
to-
doesn't mean that they will be interested. Unless you say there is some enmity or something. What was your defense?
There was the previous enmity. Out of previous enmity, the occurrence took place.
If I'll keep on asking question, then you will answer or you will tell something. I think you have not prepared properly. I'll put it tomorrow, Monday.
Monday. Well,
Prepare properly. These are the opportunity to argue extensively. Why
Right.
don't you engage this situation?
And he has also made instruction on how engaged they are in
You don't go from the court now. Sit there LCR, just check the LCR, how many days you have undergone, just check it up. And if any evidence you want to read the evidence, or get the pen drive, take the LCR with you and read and prepare and come Monday.
Well,
Okay, prepare properly. What you have to read it, I'll tell you. You read all the eyewitnesses. Okay, and because 323, 324 conviction, read the doctor's evidence and the injury, the eyewitnesses, whatever the eyewitnesses says and the victim says, wherever which part of the body injury is there, and see whether the corresponding or doctor's report is corresponding to that or not.
Well,
Likewise, you try to find out. If he says that the victim says that the accused persons have hit me in the head, and but the doctor says that the injury is found in the leg,
well,
then it mismatch.
well.
Likewise, you have.
That has been taken to consideration. For that is in 307, they have been acquitted, my lord. But
So let him do it. Let him do it. I have given you the clue, and if
Well.
you have any doubt, and you ask Mr. Ragada, he is
Well.
a senior, you can assist him, so that you can argue with you for your satisfaction.
Well.
What we will do is that a different story. Okay. Monday, huh?
Well.
Monday.
71.
Yes.
I plead your lordship.
I appointed you amicus curiae in which matter?
In one case, your lordship.
Where is that matter?
That has not come up in the list.
You give the number.
Right now, I don't have, tomorrow I will
You
provide.
give the number to Jyoti, he'll list it.
Yes, sir.
At least wherever amicus curiae is appointed, you should be alert and tell the court.
Yes, your lordship.
Yes.
Yes, the conviction is of 1 year, your lordship, for the alleged offence under section 411 of IPC, your lordship.
411.
Yes, your lordship.
Yes.
Receiver of stolen property, your lordship. Initially, FIR was registered against unknown person under section 379 and 34 IPC, your lordship.
Who are you? You are a gold jewelry. Who are you?
Some iron rod and some wooden plank. Ghar teri chalthila, that is the case of the informant. He stacked some iron rod and wooden planks. Somebody stolen that. Unknown FIR was
And it was sold to you.
No, sir. During course of investigation, I was apprehended in a separate case, your lordship, another case. It is the case of the prosecution. There I confessed that I involved in this case, your lordship.
When you purchased those purchased material.
No, the case is that I, along with 2 other persons, we have stole the property, and that property, at my instance, the property was recovered. Here, your lordship, the charge was framed under section 379 34 IPC against 3 accused persons, your lordship. And 1 was acquitted and 2 were convicted under 411 of IPC. Though this 379 charge was not established in the trial court, under 411, I have been convicted for 1 year. And I preferred appeal. My appeal was dismissed, your lordship. Here, your lordship, total 16 charge-sheeted witness was cited by the prosecution, your lordship. But during course of trial, only 2 witnesses have been examined. One is the informant, another is the IO, your lordship. No independent witness were examined. No seizure witness was examined. And it's totally, your lordship. Lordship may peruse. Page 7, page 30, running page 13, your lordship.
You are Mukesh Bari? No, you are.
I am
Sagar.
Harisankar Sagar. Harisankar Sagar. Your lordship may peruse page 13, your lordship.
1313.
No, 13. That is the list of PWs. PW1 is a Purnachandra Patel, that is the informant, and PW2 is a Rajiv Lochan Panda, that is a IO, your lordship.
13, huh? That's right.
Only 2 witnesses examined. No independent witness have been examined. And I have filed.
Basically, 1 witness.
Only 1 witness.
IO is
And that is the interested witness, that is the informant, your lordship. And the seizure list at page 33, your lordship, I have annexed. Though there are 2 seizure witnesses, but the
Let's come to
prosecution.
the finding.
Finding your lordship,
Come to the appellate court's order at page
That is-
16. Para 4.
the only point for determination is whether the accused Mukesh Barik was in possession of the stolen article. That is in respect of Mukesh Barik. And I am Harishankar Sagar, your lordship.
Where are you? Which paragraph? Which we
Para 4 of page 16, your lordship.
Yes. Reading.
The only point of determination is whether the accused Mukesh Barik was in possession of the stolen article, that is iron rod and woods, knowing that the same was stolen property. Possession in support of its charge has examined two witnesses in all where the defense has adduced none insubstantial of its plea. The learned trial court, on appreciation of evidence of record, acquitted the accused of the offence under 379/34 IPC, but convicted the accused Mukesh Barik for the offence under 411 IPC. This judgment was only in respect of Mukesh Barik, your lordship.
Where are you then? That's what I'm asking.
Exactly, your lordship. Your lordship may cost title, your lordship.
That's what I'm asking you.
Page 15, your lordship. Page 15. Harishankar Sagar.
That's what I'm asking.
Yes,
you,
your
whether it is typographical error or
I
what.
don't know, your lordship. That is the judgment. And your lordship, here also, in judgment para 1, your lordship.
You come to page 15.
There here.
This appeal is by Harishankar Sagar.
Yes, your lordship.
Okay, that is you.
Yes, your lordship.
You have filed the revision. And the judgment is talking about Mukesh Barik.
Because 2 persons has been convicted, your lordship. Harishankar Sagar and.
But it is nothing is said about
Yes, your lordship.
Yes, sir. Appellate court has not said anything against him. Not single whisper.
And your lordship, during the trial, I was in custody for 2 months, 9 days, and after conviction, I remained for 24 days. In total, 3 months, 3 days. That I have avoided in my application for bail at para 4, your lordship.
First, let us get over this. What is this confusion? Where is the trial court judgment?
Trial court judgment, annexure 1, page 7.
7.
Hmm.
Okay, file the 9. Here there are 3 accused.
Yes, your lordship.
That is Harishankar U, Mukesh Barik, and Mukund Barik.
Mukund Barik. Mukesh Barik and Mukund Barik.
Let's come to the line. Do you have the paperwork with you?
Judge, both judgments are there.
No, come to page 11 of trial court.
Trial court.
Last slide, para. See, there were 3 accused. One is Mukund Barik, another is Mukesh Barik, and third one is this petitioner.
Running page 11.
Okay. And para 7 says the Mukund Barik is not found guilty, acquitted.
Yes.
And Mahesh Barik and Mukesh Barik and Harishankar were convicted under 311.
Yes.
And accordingly sentences were imposed. And then you come to the appeal. The appeal is the appeal number 18 was filed by Harishankar.
Yes.
Against that conviction. And now come to page 7. No, sorry, page para 4 of the appellate court order. Page 16. it says the only point for determination is whether accused Mukesh Bari was in possession of the stolen article, iron rod or wood, known that the same were stolen property. And it goes on discussing.
Yes.
Where about the Harishankar?
And para 1 of the appellate
may-
court
Lordship,
judgment, your lordship may
It
peruse.
may be typographical error instead of the Sagar, it has been written Mukesh Bari.
Mukesh Bari.
What about
Otherwise,
Mukesh Bari's appeal?
constantly
What is Mukesh Bari's appeal?
there is no appeal from the Mukesh Bari, Lordship.
That instruction I don't know.
He may
Annexed,
find separate matter or
your
separate
lordship may peruse page 15 at least. Page
Separate
15.
okay.
Yes.
Page 15, the first paragraph itself.
Yes.
This is an appeal against the judgment of conviction and order of sentence passed by the learned James Palangi in such and such case
Very
number.
simple.
The appellant herein referred as the accused
Mukesh.
to rigorous imprisonment for a period of 6 months. Whereas the award was 1 month, 1 year, your lordship. Trial court has awarded 1 year. But right from the beginning, it said, I've-
Order लिख लो मुकेश में.
And the first paragraph also says rigorous
Yes,
imprisonment for
sir.
6 months,
Yes,
where 1
yes.
year sentence.
Yes, sir.
What is this? Shall I set aside and remand?
No, your lordship, after from already in custody for 3 months and some days, your lordship, out of 1 year. Remand करे 11 वर्ष 12 वर्ष.
किंतु witness रही थी सागर.
What is this? Completely non-application.
Yes, sir.
Completely.
Perhaps if I don't know actually second person has filed the appeal or not. If that would that he has filed the appeal, that same has been type here.
There are
No, typo I can understand para
they
4.
have
Para 1 also.
all other accused persons also file appeal there, my lord. Just type cloud
So type para 1 re kon kohuchi? Para 1 re he should have.
Yes, Mukesh, that Mukesh is
all
there.
cases
No, no, sentence is 1 year, sir. Just see sentence. Just see sentence. What is the sentence?
Shut up. You've already.
RIF for period 1 year. Trial court imposes RIF 1 year. And the appellate court in the first paragraph writes no 6 months.
Yes.
One typographical error one can think of.
No, there are other convicts they are prefer for appeal or not, that is the one that whether they have prefer appeal or they have committed or filed.
And there are only one witness basically.
One witness.
That is interesting.
IO is not exactly
Yes.
witness.
Only informant.
He has to land support only. What is there? I don't understand.
No seizure witness was examined. That was the prosecution didn't prefer to examine. Page 8, para 5, your lordship. Turning page 8, para 5. In order to prove its case, the prosecution has examined 2 witnesses out of 14 charge-sheeted witnesses. The learned APP has declined to examine the rest witnesses.
They are so confident about one witness. Why should they do it? File a short note. I am reserving. It's a case of acquittal. Why? Acquittal. You give a written note with page number and all. Okay. Yes.
Sorry, my lord. I come systematically late. Any day, my lord. Are there any? 72.
Yes. Yes, Mr. Chaudhary, are you appearing in manual? Yes.
Meet TP Jewelers. Here, my lord, after about 28 years of the case, the appellant is placing his grievance before the Honorable Court. The present appellant has been convicted under section 7 of the PC Act.
Appeal of 2006.
And the occurrence is 96. And he has been sentenced to undergo 6 months.
Nay, you were 62-year-old.
At that
Year
time,
2006.
now 80 years. And the matter, my lord, might have 20 rupees towards prescription fees. This is the only allegation. And so far other parties concerned, if I will place everything before my lordship will astonish that how this case has been conducted in the lower courts. The IO who has submitted the charge sheet He was no more in the picture. Some other persons were there. TOL is there. And the reason best known to the IO, under what circumstances, all the documents were prepared by the IO, who was no more present at the time of preparation or at the time of detection. Your Honor, my Lordship will be astonished under what circumstances this case has been created.
How the trial court and High Court.
Yes, my Lord. That will be placed before my Lordship.
Right. Let us see. Ready?
Yes.
Are you waiting for natural death of file or natural death of the accused?
8 years now. Is better written.
Yes. Let's proceed.
My Lord, so far the judgment of trial court is concerned, it is based upon the evidence of PW2, who is none else but the decker of this case.
Yes.
I think that before submitting the placing the
you tell me the best point you have.
My Lord.
If I satisfied, then
yes, my Lord. My Lord, I know.
You need not
Just I was taking with my learned friend. That
best point.
only on the basis of decoy, the order for conviction has been passed.
Yes.
So for the PW1, who is the magistrate witness, and PW3, who is the overhearing witness, they were declared hostile.
Okay.
They did not support. Now, what are the materials available on the record? So far, relying on the evidence of PW2, the learned court below has convicted. But only few lines of PW2 I'll place. Thereafter, all the details.
Right.
Place.
Give me. PW2.
Yes, ma'am.
PW2.
Page 58.
58. Yes.
Only some relevant paras I'll placed.
Yes.
How it is not corroborated from the evidence of other. Paragraph 3, running page 59. Though there is some typological mistake.
There is a paper book.
My Lord.
Yes,
There is paper.
Give me the paper. They are referring to paper book.
My Lord.
Yes. Yes, sir. 50.
15, running page 59, paragraph 3.
Handwritten document.
Running page 59 of paper book.
This paper.
Yes, my Lord.
59. One paper book you have. 59. Yes, 59. Right. Para 3.
Para 3.
Yes.
Though it is a typological mistake, then we proceeded to Athantara. I went to my in my scooter to take the daughter along with me to the hospital. Other went to the government hospital. Myself and the witness Mohanty went inside the hospital building. From among others, 2 remained inside the hospital premises and others remained at short distance. The doctor examined my daughter and asked me to give money. I gave the money.
You are a government doctor.
My
Yes.
Lord.
Yes.
Witness Patnai Babu, not Mohanty Babu. Then he twisted this sentence. As little error, gave the pre-planned signal. Receiving the signal, the trap party arrived. Vigilance staff gave their identity to the accused actors. I disclosed the vigilance officer that on demand I gave the money. The vigilance officer challenged the doctor who have received the money, but the doctor denied. The search of accused was taken by one vigilance officer, recovered the note from the short chest pocket of the accused. Only I am giving this that so far the recovery part is concerned. Then, my Lord, I will draw that.
After hand was
that is
recovery is proved.
Yes.
Recovery is proved.
Right.
But how far this found corroboration from the evidence of other witnesses? So far the recovery part is concerned. Whether he himself gave the tentative
Phenolphthalein test is positive.
Positive.
My Lord.
Right.
Test is positive.
Right.
And that also negative I will negative everything. So far that chemical examination report is concerned, that sanction is concerned, everything I will place position. Everything is wrong. How the person has been convicted on a wrong motion. Thereafter, my Lord, paragraph 4, running page 60. Only few lines nothing, I will not spoil the value of time of this report. Paragraph 4, sixth line, perhaps, second thought. I do not know if the doctor used to see the patient in his quarters after or before his official duties. At the time of going to hospital, I was not collecting any outdoor slip, but I was directly contacting the doctor who used to give prescription. I have never taken a prescription from accused in any printed form or printed pad disclosing his name or clinic. On 8/10/1996, only my daughter was examined by doctor, but not any other persons of family. On 8/10/96, the doctor gave a prescription. The prescription was taken from me by the vigilance officer. I know the accused has a clinic inside the medicine store of Basant Patnaik at Balakati. So it is.
You have a clinic also?
Yes, I have a clinic, and I've been authorized to go for private practice as per the circular. Now, running by 61, seventh line.
Show me the circular.
Yes, yes, member. I possess the circular.
Have you exhibited that?
Yes, no, exhibited. It is not. It is a circular of the government.
In 1996, it was prevalent.
99, I think. 90.
I'm
Government
talking about
reduced to 90.
90. Show me. You can practice.
को माने करि परिबेनी सेथरे स्पष्ट लेखा जो को माने करि परिबे सेथरे लेखा
को पारा
नहीं नहीं सेटा एंटर प्रेजुलेशन माय लॉर्ड
सो मी रेलेवेंट पार्ट
नहीं सर माय लॉर्ड सब जगह जी जे करि परिबे तंग ना अछि सेथरे करि परिबे नाही सेथरे माय लॉर्ड टेक ए पेन फॉर दिस second phase and it is ended in third phase. Nowhere there is a restriction to practice private. That has not been dealt with by the learned trial court.
Is there a complete ban? Was there any complete ban?
No, no, my lord.
My lord, sir, DW3 is the accused himself who has been examined.
I'll forget about everything.
Right.
The allegation against him is he has taken money from the patient in the hospital for treating her.
For treating.
Evidence has come on record that he has a private clinic.
Yes.
The only offense what is alleged by you is he could have done whatever he want to do in his clinic, it's all right. But in the hospital, he should not have taken.
Yes,
money.
Yes.
That's the long and short of it.
Yes,
Yes.
that is
And how much he has taken?
20 rupees.
20 rupees he has taken. He is a doctor.
Yes.
If the private practice is not completely banned, the only mistake what he has committed is instead of asking the patient to come to his clinic,
He has come
he
to the
has
hospital.
taken 20 rupees. Why are you after his life? Forget about the merit and all, everything you forget. He is 80-year-old man. Tomorrow he is going to die. Let him die peacefully. Unnecessary. And what do you have anything to say?
I will.
I like it.
Lord,
Forget about everything.
I will file a written convenience note for your lordships.
You file it.
Yes.
I'll also file it.
Judgment trigger.
Oh, yes.
Forget about technicality. Yes. Poor guy, the 20 rupees. He has taken. And what he should have done is he should have called the patient
To the clinic.
clinic.
Greatly obliged. Man.
And what doctor you are a medicine specialist?
Medicine specialist.
It's GP, man, general practitioner. He's not a medicine.
He must not having good practice. Why then 20 rupees? He is so desperate to take 20 rupees in the hospital.
My lord, the defense what he has taken, my lord, the defense what he has taken, that this decoy has brought his daughter for treatment. He treated his daughter, prescribed the medicines. Then this decoy went to collect the medicines from the medicine store. There, the medicine amount came to 120 rupees. 20 rupees was shortage. So he came back to the doctor and doctor gave him 20 rupees as well.
And if he is caught in the wrong side of law, he has to take some defense.
Yes.
He has taken some defense. What to do?
So this is the ball defense.
Get rid of the problem. He has done
And it has also been brought out from his mouth that even if so many persons were treating there, from nobody he has taken money.
You tell me, at the time of the incident, you were employed that you were terminated from service.
No.
We were there, man. Not terminated.
What about your service, this pension and all? Are you
Pension
getting-
is not, that is why application was moved for granting of pension.
The provisional pension you must be getting.
Yes, that was there.
As the only dent in the prosecution cases, my lords, is that overhearing witness and magistrate witness have turned hostile. That is our difficulty. my lords. That is the only dent in the prosecution case. Otherwise, you had a strong case.
Once he will be acquitted, at least he'll get his family
Yes.
pension and all.
But bereft of this my lords, hostility of the witnesses, my lords, Section 20 presumption is also there, your lordship knows. If your lordship gets into that.
Give a small note.
Yeah, I will give it.
My lord, I'm said that he is not receiving any pension. Provisional pension is not receiving.
He has minted a lot of money from the clinic. He doesn't want. Okay, give a note.
My lords, I'll file a convenience note within 7 days. my lords.
Yes.
Oh, bless.
Within a week or so.
1 week.
Yes. Item 40. 40. 40.
My lords, judgment reserved. my lords. Hearing concluded, judgment reserved. my lords.
Hearing concluded, judgment is there. Yes. Yes, sir.
My lord. My lord, the case is this, that the petitioner was working as a gardener from the year 9.
Ready? Who is appearing?
I'm
ready.
I'm not ready, perhaps. Let
Well,
him submit his part. If your lordship may fix another date, I will conclude on that date. I will give the reply. And
Same day we will do it. Why?
as your lordship pleases.
My lord, a very small point, my lord, in a similar instance, my lord, the other persons who stand in a same case of trial, they've already been acquitted by the ordered judgment dated 31/1/2022.
Same case or something?
No, my lord. My lord, what has happened is, I'll just explain in brief. The director of horticulture was given certain funds to buy banana straps at one rate and then give it to the farmers at a subsidized rate. So these people, all of them have been given certain amount of money from that 2,10,000 rupees. Some have been said to have misappropriated 19,000. That is the one in which the acquittal has already happened. This person has misappropriated 16,000. The witnesses were there who said that they have not purchased from us and we have not signed on the receipts. This honorable court has held that no, that is not the sin. The court finds that this 409, 420 and other offenses are not made out because of the deposition of because of the lacuna in the prosecution's case, that they have not seized the central stock register in which this entry was made, and the disbursing authority had satisfied himself that yes, this is correct. On these two grounds, my lord, all of the offenses have been said to be not have been made out.
Yeah, that case.
In this case.
So you do have a copy of that?
Yes, my lord. But
Give
this-
give it.
Is it out of the same PS case? Same year?
I'll just say.
You just check it up.
Yes.
If
so
my-
that we can conclude the hearing.
Now it's
No, not now.
So, I
As
will
per
go
your
through it.
convenience.
I will go
Tell
through
me.
it.
Next week?
Yes.
You tell me.
Second week of July, not because already in first week of July, lordships have fixed some matters.
Second week of
Week of July.
Because in the fragmentation, I'll hear it, forget it.
Yeah.
That's right, your
Madam,
lordship.
that's
Then
correct.
again you start, then
That's
no
correct, madam.
use.
That's correct.
So you take the judgment.
Yes.
On the basis of that judgment, you just address.
Yes. Right.
If the same benefit could be given,
then
definitely we'll give.
Yes.
There is already there is a-
Because he is the person who says that he has given advances to me, and from that money I have made purchases. And the prosecution case is this, that the vouchers which have been signed by these people have come and deposed in the court that no, we have not given any vouchers, we have not received this much amount of money. And accordingly, my lord, the court has held that 16,000 odd something has been misappropriated by me. But my lord, this judgment will come to my help with the findings that are there in support, saying that when the same in-charge horticulturist, the disbursing authority has accepted that, which is PW9 in this case and which was PW10 in that case, has categorically said that no, as the disbursing authority, I'm satisfied and these have all been done rightly. And the prosecution did not seize the stock register.
Then the independent witnesses version has to be
Yes.
discarded.
So these people who say that no, you have not taken money, the court has disbelieved in the appeal.
Because
the disbursing authority, as on PW9 has said,
that is the crux.
that is the crux of the
That is
matter.
the crux.
Because as it appears, these are two different TR cases. But
No, different. What he says is, try to understand. What he says is, the money was disbursed to XYZ.
Yes.
And the XYZ come to the witness box, says that no, it was not disbursed to me. On that basis, case is built up.
Okay.
But while the money was disbursed to XYZ, it was through the sanctioning authority. The sanctioning authority is accepted to be true. Then
Yes.
credence has to be given to the sanctioning authority, not to the witness's testimony.
Correct.
That's what he says. And the conviction is based on the testimony of XYZ.
Yes.
That has to be discarded.
Yes.
That's what he says. That is the reasoning in that judgment.
Correct.
I will
If
go
that
through.
reasoning comes to the aid of him,
Yes.
then he is entitled for it.
I will go through it.
That's the.
That is the point, Your Lordship. So, Your Lordship.
That's what his allegations are in similar nature.
Yes, my lord, I'll even show from that judgment itself that this person has been named in that judgment. The director of horticulture is the same. These people are the same. The IOs is the same.
Then my lords, I will go.
The link. There is
Yes.
a link.
And 11th, my lords, 11th of July.
11th July.
I'm grateful, Your Lordship.
And parties are directed to file a written note of submission, not exceeding 10 pages.
10 pages. Your
Not
Lordship.
exceeding 10 pages.
Your Lordship.
You confine it to 2 pages.
Yes, Your Lordship.
Right.
64.
May please, Your Lordship.
Yes.
But here the conviction is convicted under section 323 and 324, Your Lordship. Under 323, 1 year imprisonment, and 324, 3 months imprisonment. Your Lordship, the matter was called yesterday, and Your Lordship knows that the injury is simple in nature, and the state was, I already given a copy to the state yesterday itself. So, Your Lordship, the crux of the matter is, the background of the matter is that these petitioners, these accused persons, they attacked the informant and his father while they were working in the field. This is the allegation, Your Lordship. And as per the medical examination report, and so the injuries were found to be simple in nature. 3 injuries were found to be there. One in the thumb, one in the upper tip of the ear, Your Lordship, left ear. And here the PW3, the conviction was based on the statement of PW3, the father of the informant, Your Lordship. And Your Lordship kindly looks at page number 20.
Who is the injured witness?
PW3, Your Lordship.
PW3. He is the
Yes.
informant.
Yes, sir. So the court, the learned trial court, admitted that he exaggerated the issue and he exaggerated his statements, and thereafter he concluded that even though despite the exaggeration, the entire thing cannot be thrown out. So basing on that, and he did not extend the benefit of the PO Act, Your Lordship, even though the petitioners are first-time offenders, and there is a case and a counter case.
You are interested in PO Act?
Your Lordship, on the merits also.
PO Act, you take the PO Act.
Yes, Your Lordship.
PO Act.
Yeah.
Okay. Hello. Benefit of PO Act. First-time offender?
First-time offender.
Yeah. Visual judgment. Video अगली कर.
Note